Testing, 1, 2, test. Hearing Officer Little, we are on the record.
Good morning. It's July 10th, 2023. Assessment Appeals Hearing Officer is hereby called to order. Would you do roll call, please, Brendan?
Yes, and Patricia Little will be our hearing officer today.
Present. Please stand for the Pledge of Allegiance. Ready? Begin.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
You guys, if everyone could remain standing, those of you addressing the board today, addressing the hearing officer today, both in person and on Zoom, I'll place you under oath. When I complete reading your oath, state I do. Please raise your right arm. You and each of you do solemnly affirm that the testimony you're about to give and the matters now pending before this hearing officer will be the truth, the whole truth, and nothing but the truth.
Thank you.
Thank you. You may now be seated.
All right, agenda review.
Yes, item 5, agenda review for July 10th, 2023. The clerk of the board requests approval of the agenda review by the Assessment Appeals Hearing Officer. The agenda review consists of the following agenda items. Item 13 and 14. Application numbers 22-10176 and 22-10193. Reisman Family Trust, continue to October 23rd, 2023, pending receipt of originally signed stipulations. Item number 19, application number 22-10631, applicant Tim A. Donis, denied due to lack of appearance. Item number 20, application number 22-10740, applicant Elon Antebi, denied due to lack of appearance. And number 21, application number 22-10853, applicant Sully Anok, denied due to lack of appearance. Item number 25, application number 22-10961, applicant James Ben, denied due to lack of appearance. Item number 26, application 22-10967, applicant Carl Watt, continue to October 23rd, 2023, in receipt of an original stipulation. Item numbers 27 through 28, application 22-10968 and 22-10969, applicant Jason Kimball, denied due to lack of appearance. Item number 29, application 22-11004, applicant Michael Johnson, denied due to lack of appearance. Item number 31, application number 22-11105, applicant Daniel Sternberg, denied due to lack of appearance. And item number 33, application number 22-11454, applicant Wayne Weedick, denied. Okay, we will not deny item number 33. That completes the agenda review. Hearing Officer Little, recommended action is to approve.
So ordered.
In just a moment. Proceed.
All right. Are there any public comments, anything other than what's on the agenda today?
Hearing Officer Little, everybody checked in today appears to be for an item on today's agenda.
Okay. And no hearing officer comments.
All right.
All right, at this time, we're just going to run through the agenda to confirm if we're going forward with your case today, or if there's anything we can take care of very quickly, we will. And we'll see how many cases we'll be doing today.
All right, and then we have a number of people in person as well on Zoom. When you hear your name called, please press the raise hand button if you're on Zoom, and then we will enable your microphone. Thank you.
Okay. I'm going to call your name. If you can give me an idea about how long your case presentation will take, that would be very helpful. All right, items 8 through 10, applications 21-10314 through 21-10316. John Williams.
Yes.
Good morning. Good morning. Are we going forward on your case?
Yes, we are.
Okay. With about how long do you think your presentation?
Minimum 15 minutes
Okay, and to the
on
assessor?
my part. I'm not sure about Dave's.
Okay, and to the assessor?
Good morning, Steve Bates with the assessor. We anticipate the same, about 15 minutes in our case. We are prepared to move forward.
Oh, yes. Thank you. Okay, item 11, application 21-10335. Brandon Hanson.
I do not show anybody checked in for this item. If you're present on Zoom for this item, please press the raise hand button now. Hearing Officer Little, I am not seeing anybody. Notes indicate I spoke with Mr. Hanson last week and he indicated he'd be attending the requested continuance. As he's not present, recommendation is to deny due to lack of appearance. If he appears before the end of your hearing today, we can reopen the case.
All right. So ordered, denied due to lack of appearance.
Thank you.
Item 12, application 22-10173, Doris Swinehart.
Yes, for the record, a withdrawal was received this morning and the application is now closed. No action is necessary by the hearing officer.
So noted. Item 15, application 22-10252, Jayesh Patel.
Yes, we have Jayesh Patel on Zoom for this item. Are you there?
Yes, I'm here.
Good morning. Are we
Good
going
morning.
forward on your case today?
Yes, and assessor is, I talked to assessor and there is a scheduled meeting. So next week.
Oh, okay.
Yeah.
To the assessor?
Yeah.
The assessor, yes, thank you. The assessor is requesting a continuance on this case to allow more time.
For a site check.
For a site check?
Yeah,
Okay.
scheduled next.
All right, Mr. Patel, and for anyone else here today that's going to be requesting an extension, we only have one hearing left this year, which is October 23rd, 2023. And then tentatively for 2024, we may have February 26th. Anyone who'd like to reschedule, if there's no objections, we'll reschedule you to October 23rd. If you're not available that date, we will do tentatively for February 26th. Mr. Patel, are you okay with October 23rd?
Yes, I'm okay.
Okay, and to the assessor, are you agreeable with the 23rd?
Yes.
Do you need any kind of a data proviso or do you have everything you need?
Just the site check.
Okay. And back to the applicant, Mr. Patel, are you agreeable with the site check?
Yes,
Excellent. Okay, we will continue this case until October 23rd, 2023.
thank you.
Thank you, Mr. Patel.
All right, item 16, application 22-10363, Merrill Russell.
We have Ms.
Yes.
Russell here in person.
Good morning. Are we going forward on your case?
We are,
Okay, about how long do you think your presentation will take?
about 20 minutes.
To the assessor?
The assessor is prepared to move forward on this case. We anticipate our case will take about 15 minutes.
Yes. All righty. Okay, item 17, application 22-10396, Patrick Nayland.
Yes, we have Mr. Nayland on Zoom. Please unmute. Thank you.
I'm here.
Good morning. Can you hear us okay?
Yes, I can.
All right.
Turn
Are
him up.
are we going forward on your case today?
Yes,
Okay, and about how long do you think your presentation will take?
10 minutes.
All right, to the assessor?
The assessor is prepared to move forward on this case. We anticipate 15 minutes for our case.
Okay. We will come back to you when it's your turn. Thank you. Item 18, application 22-10578, Masood Ashfar. Good morning. Are we going forward on your case today?
Yes.
About how long do you think?
5 to 2 minutes.
Okay. To the assessor?
So the assessor is requesting a continuance on this case to allow time for a site check. Yeah,
Okay. Okay, back to the applicant. Are you agreeable with a site check?
I have no problem with the site check, but the reality is that the assessor at the talks is out of touch. She said replacing a 14-year-old faucet is $50. That is out of touch.
Okay, yeah, I don't want
I
to get
have no
into any.
problem. They can come and I have no problem.
Okay, okay.
Is October 23rd okay with you?
Just in case you can't come to an agreement with the assessor, we're giving you a continuance to come back here October 23rd. But a lot of the times when you meet with the assessor and discuss things, you come to an agreement.
Are you available October 23rd?
I said,
If not, we can do February 26th, because you'll be required to attend the hearing. So does October 23rd work?
Yes.
Okay.
To the assessor, October 23rd?
yes.
Okay. And do you need a date of proviso or any?
Just the
conditions?
site check.
Just the site check. Okay, and the applicant is agreeable.
What time?
9:30 a.m. on October 23rd. In the same room.
Okay, so we will continue to October 23rd, 2023.
As soon as she approves it, you're all set.
So ordered. Thank you.
Yeah, you're free to
Thank
go. And anyone that continues is also free to stay and observe the process as well.
All right. Takes us
Thank
to
you.
number 22. Thank you. Sir. Application 22-10857, Michael Baum.
He's here in person, correct?
Good morning.
Good morning.
Are we going forward?
Yes.
And about how
5
long?
minutes?
Okay. To the assessor?
We're requesting a continuance. We requested data from the applicant, which hasn't been provided.
Okay.
We don't agree with that because we don't have any more. They just simply asked us if there's any more receipts. We don't have any more receipts.
So there is no further data.
And have you documented that in writing to the assessor?
Yeah, we've told them the issue is not
No.
the receipts. The issue is the percentage that they're claiming the property is progress, which is not correct.
Well, then we would request a continuance for further discussions. Emails and phone calls were left unanswered. And per our last conversation, he had the information that we had requested and he had planned on providing it today, thinking that providing it to us was only going to expedite the hearing. So this is the first time I'm learning that he doesn't have any further data.
Okay, and have you been in contact with your,
Every single time we return that phone call, yeah, I'm not sure what the.
That's incorrect, but the last conversation we had was only because Brendan had reached out and
who is their case
me.
person? Okay, and you've
I've sent
exchanged-
emails, he confirmed he received them, he just never responded.
Okay. And you've confirmed the phone numbers are correct.
Yeah, I'm actually gonna. Emails have been, which email are you referring to that was not responded to?
I would have to go back to my spreadsheet.
There's 2 emails, one,
That's getting, I mean, that's,
Okay, well,
we can
is
discuss
it
this
the
later,
same,
but
it's fine.
you've got phone numbers, okay.
Yeah.
And is there any chance, since he's here today, you can have some discussion in person today? Or do you have other cases?
I have
going
other
forward?
cases, yeah.
Okay.
So, and I did inform him that I would be requesting a continuance.
Okay, I would,
If that's the case, can we request to have the case be heard by somebody else by the city, by the county?
a different
Yeah.
hearing officer?
Yes,
Okay,
not.
or,
from
a
the
different
county,
assessor.
Correct,
okay,
because
They
I
might-
just feel like we responded to every phone call, and I thought we've been more than very attentive to respond. So if that's not the same view you have of us, I'd rather have somebody else here.
Okay, to the assessor, is there someone else you can appoint this case to?
We can, yes,
Okay, and they will reach out to the applicant.
yes,
Okay, that would be fine.
Yeah.
We can
Okay.
reschedule.
okay.
Thank you.
And is October 23rd of?
That would be fine.
Okay,
And hopefully, when discussions start, it always seems, they have a way of working. things
Yeah,
out,
no,
and
it's
then you
fine.
don't
I
have
just,
to appear.
we're not seeing eye to eye.
Okay, no problem. All
so
right.
I just wanted to be clear since we're on record now, so, because the assessor indicated they didn't receive the email, so you're indicating the information the assessors requested does not exist, is that correct?
Well, no, the whole discussion was, is there any more information that you can supply to us?
Such as
Make-
labor costs and
Correct.
other than the lumber.
Correct. And this is not a regular, I don't want to go into the case right now.
Right, I just want to make sure it's clear.
I thought we were pretty clear that that wasn't the issue. The issue was the percentage of the property that has been
Percentage
completed,
complete.
completed.
Mhm.
That was the issue. So if that's the, yeah, let's just, that's fine. Let's just.
If this is, we make it clear for the record.
We don't have any more.
It does not exist, okay,
Yeah.
okay.
And they requested if you have something, bring it, and we don't, so.
Yeah, so this is for clear, if there's any additional information, make sure to supply
course,
that
of
30 days
course,
in
of
advance. Okay.
Is there perhaps a site check that needs to take?
A
place?
site check was done by the area appraiser who was working the new construction. In correspondence with Mr. Baum, I indicated what that 40% of the cost initiated entailed. We had agreed we were up to a framing. I let him know what that included. So if we're both in agreement that we're at the same stage and what that includes, I don't know where the discrepancy would be.
Yeah, and I feel as though
Can I
our,
respond to that?
I just feel though our appraiser has done what's
So
been
not only the
expected.
residential for the new construction, but we received 30,000 in lumber costs only for new SFR, and that's, I'm pretty sure there's more costs than just lumber that were entailed.
Are we
So-
doing the
Okay.
whole case right now?
No, but I'm
I can
just
go
letting
get
you
it,
know.
I can
I'm just,
respond.
I was just asking if a site check had taken
A
place.
site check, yes,
Well,
was
the issue
conducted.
is, this is not a regular project that's being done by a contractor. We're literally doing the work.
Mhm.
Thanks to friends and family, it's been already as, it's very I don't want to get into it again, but if you want, we could. The issue is, they're claiming at that point, the framing was done, which was not done. I have pictures that we
And-
have, yeah. Do you have?
Okay.
Yeah.
Okay, I'm gonna let you
Yeah,
have
so we'll-
discussions
Yeah.
with another
Yeah,
contact
let's
person
do
from the
that.
assessor and,
Because I understand that taxes go on whatever is completed, not in the process. Is that correct? or
That's
no?
incorrect.
Incorrect? So if you just start one wall, you just get taxed for the whole.
Let me, let me make sure if your appeal should be selected based on what you're telling me as a construction in progress appeal.
Correct.
Let's, I don't know if that's what was marked. Okay, yes,
I
it
believe
is
it was.
construction in progress, so your appeal is properly challenging construction in progress as of January 1st, 2022.
okay, so, we will continue this to October 23rd, 2023.
You're all
So
set?
ordered.
Already, thank you.
Thank you.
Yeah, okay.
And I'll
Alrighty.
provide you my.
Items 23 through 24, applications 22-10903 and 22-10905. The Samulich Trust.
Yes, we have Nick Samulich on Zoom for this item. Are you there?
Yes, hello.
Hello, good morning.
This item was no confirmation of appearance. Mr. Simlich did reach out after the 21-day deadline to reschedule. So I informed him he would have to attend today as is policy since the paperwork wasn't received at least 30 days prior to today's hearing. He is required to request a rescheduling.
Okay, we're looking at October 23.
Okay. Yep.
Is that agreeable? And
Yep.
to the assessor, do you agree, October 23rd?
Yes,
Okay, do you need a data proviso? Is there any information missing
if we can add a proviso, yes.
30 days prior to the hearing?
Yeah, that would. Because it's stretched out so far, that might be a good idea.
Okay.
Yeah.
Okay, back to the applicant. The assessor might need some more data.
Uh-huh,
So they're asking for what's called a data proviso.
okay,
In the event they need anything, you'll provide them to the best of your ability. You'll
Uh-huh.
provide them the information or the answers, let's see, 30 days prior to the hearing, which is October 23rd. Is that agreeable?
sure.
Okay, we will continue to October 23rd, 2023, with the proviso that any information requested by the assessor be received by the assessor at least 30 days prior to the hearing.
And so they'll reach out via email or in writing
Yeah.
in the mail?
Yes.
Okay, sure.
Yeah.
Yeah, my understanding was, based on my last conversation with Joe Vernon was, I was working on getting quotes, which I'm just missing one critical one. That's why I wanted to, request the extension of the work that needs to be done to the vessel. So, I would have had it if it wasn't for the holiday weekend. So, yeah, I should have it by then. No problem.
Excellent. Okay, thank you.
You're all set. Have a good
So
day.
ordered. All right, takes us to item 30, application 22-11054, Douglas Sullivan.
This applicant had contacted me last week, indicating they would be attending the request rescheduling. However, they are not currently present, and they did not submit the required confirmation of appearance at least 30 days prior to today's hearing. So recommendation is to deny due to lack of appearance.
So ordered. Item 32, application 22-11168, Jeffrey Simonson.
Just a moment, sorry.
It's okay.
Yes, we have Mr. Simonson on Zoom. I'm going to go ahead and enable his microphone. Please unmute. Thank you.
Good morning.
Good morning. Are we going forward on your case today?
I was also just gonna request an extension, was unable to put in my information prior to the 30 days of today.
Okay. So we're looking at October 23rd. Is that agreeable?
Yes, I think I'm gonna try to get all the information I can to the assessor and have it resume before then, actually.
Hopefully. And to
Yeah.
the assessor, October 23rd.
Yes,
Yeah.
the assessor is agreeable to October 23rd. If we can add a proviso for data, we haven't received anything.
Okay, 30 days prior to the hearing,
Correct.
adequate?
Yes.
Yes,
All right, and the applicant agrees. Okay.
yes.
Excellent. We will continue to October 23rd, 2023, with the proviso that any information requested by the assessor be received by them 30 days prior to the hearing. Okay.
Perfect.
So thank you.
Thank you.
All right. Agenda item 34, application 20.
33 was removed from the.
Oh, I'm
vendor
sorry.
review.
You're right. You're right. I circled it. Item 33. Thank you, Brendan. 22-11454, Wayne Weedick.
You, Mr. Weedick, thank you. So we didn't receive your confirmation at least 30 days prior, so you'll be required to reschedule your hearing today. But feel free to address the hearing officer.
Yes, that'll be fine. I do have some, documentation. This is gonna be a little bit, maybe a little bit different than some of the other cases as far as value of the house and other, property taxes paid for value, so mine. So I will have something for that, but that has to be 30 days before the October, like.
The
photos.
sooner, so
Yes.
most appeals are resolved without a hearing. Today is the only if it can't be resolved. So you should reach out to the assessor. Is Ms. Ramirez assigned to the case? and provide them what you have and then see if the appeal can be
To you,
resolved.
to your son.
Yeah, that would be,
And what was be so kind, the case number?
Your case number is 22/11454.
22/11454.
So you should reach out to the assessor as soon as possible and no later than 30 days prior to October 23rd. But you can begin resolving this, this
I
week,
see. And what time, October 23rd?
9:30 a.m.
And do you have the assessor's contact phone number?
I've spoken with Brenda before. He probably remembers
Okay.
me.
Let's-
We've spoken.
Yeah.
And
you
to the
have business
assessor,
cards?
do you want to supply the applicant?
Just give you a business card, that we don't have with us right now, but we can just write it down on a piece of, yeah.
thank you.
But yes, the assessor is agreeable to continuance on that one.
Okay.
With the data proviso, do you prefer 30 days from today or prior to the?
I mean, 30 days from today would be great, because then
Okay.
there's a
30 from
possibility we
today.
could
Yeah.
Okay.
come to an agreement prior.
Okay.
Since it hadn't been.
So by September 23rd.
At the latest, sometimes when they get some information, they always have additional questions
Sure.
or.
So I believe Ms. Ramirez is requesting within the next 30
30
days.
days.
So any information you can give her by August 10th, would that work? Whatever you have. So the hearing would still be October 23rd, but then in
I might need a little, since I'm on to a little different tangent here, as far as the value, it might take me a little bit. I'm working.
Okay.
some-
So maybe 60 days from today?
Yes.
Or would that put
60
us?
days.
Yeah.
60 days from today.
That put us-
Okay.
So October, so that would be September 10th approximately.
September 10th.
And I can call if I have it ready before.
Yeah, as soon as you have the information you want, and whatever you have now, provide to Ms. Ramirez and she'll let you know if you're headed in the right direction or not.
Is it possible to meet in person than emailing and doing? I think it would be a lot more time efficient for us. Is
Sure,
that a
yeah, we can
possibility?
schedule a time,
That would be excellent.
just, yeah. I'll get in contact with you after the hearing today, where we can schedule a time.
So so I'm waiting then till we finish all this up and we'll talk again further? Today, you said after the hearing today?
Yes, I believe there's maybe 5 cases
Yeah.
today, so it might be a little bit lengthy. If
Yeah.
we break,
And we're not sure what time it will end, so. in
Oh,
all
so-
fairness-
Schedule a time.
So-
Yeah, schedule.
if it's possible, if I could call you later today from.
Oh, right, I
whenever
don't
we
need to
have-
wait till this is all over. I gotta
Right,
get back to
you can-
work.
yeah,
Have it
exactly.
not till right.
Exactly. I'll
We
give you
won't
a
have to
call.
worry about the property taxes.
Yeah,
My
I'll give
bosses.
you a call today, and then we can schedule a time if you'd like to come in.
Sure, you can do that. You have my phone number then.
I should if it's if it's the correct number on the application.
Okay,
You received the emails regarding today's hearing?
I got this in I think where did I get this?
Is it a blue paper?
Yeah,
Okay, so you did not receive the email.
I don't know.
I just want to make sure if you
I'm not
received.
gonna go there and say, because I get
Yeah.
bombarded.
I just
Just to
wanted
be
to
sure we
I
have
was
the
trying to
right-
verify if we had your correct email address.
It's- WAYNE.
And it's your first name underscore your last name at yahoo.com?
Yeah, WIEDECK.
Yes, we have your email address on file. Just make sure to check your junk mail folder in case you're not receiving the emails regarding the appeal.
Okay, yeah, but I just,
thank you.
We'll be in contact.
so,
Okay, so we will continue to October 23rd, 2023, with the proviso that any information, further information that the assessor might have, be received by the assessor within 60 days from today's date.
yes,
Okay. That's
and if you get busy, don't call me today. I'll definitely reach out.
Okay.
To you and we'll get together probably before the 60 days in person.
Perfect.
And that would be at this office?
Downstairs,
downstairs.
first floor.
Thank you.
Uh-huh.
Good luck.
Thank you.
everyone.
Okay, thank you. Very good, so ordered. All right, now item 34, application 22-11488, Calvin Inouye. I will spell the last name, INOUYE.
Have no one checked in for this item? Oh, we have an unnamed person on Zoom raising their hand. Let's go ahead and allow them through. Oops, sorry, let me. I don't know what's happening here.
Oh,
What happened?
oh, I'm sorry. Oh, yeah.
There we go, sorry about that, you should be able to unmute now.
Well, I've heard this.
Right.
Can you hear me?
Yes, we can now, and you didn't sign in with your name, what is your name, please?
Calvin Inoue?
Thank you.
Alrighty. We have no confirmation that you would appear today, so we will have to continue your case.
Okay.
We have October 23rd available,
Okay.
right? And to the assessor, are you agreeable? October 23rd?
Yes.
Ye-
Yeah, the assessor is agreeable. We could also add a proviso for data, so we haven't received it.
All right.
Yeah.
Back to the
Yeah,
applicant.
I guess I kind of screwed up by not having the information prior, the 30 days prior, which I guess I didn't know, but can I get the information to them prior to October?
Yes, as soon
Okay.
as you have it.
Yeah, and we can add it 30 days from today.
Within 30 days from today, is that okay?
Sure.
Excellent. And you have the assessor's contact information?
Yeah.
Okay, excellent. Okay.
Great.
We are going to continue to October 23rd, 2023, with the proviso that any data requested by the assessor be received by their office within 30 days from today's date.
Great. Thank you so much.
Okay, thank you. So ordered.
Bye-bye.
All right, item 35, application 22-11506. Christopher Glasgow. Good morning. Are we going forward on your case?
Yes.
All righty. About how long?
10 or 15 minutes.
10? Okay, to the assessor.
And the assessor is prepared to move forward on this case. We anticipate 15 minutes.
Excellent. All righty. Item 36, application 22-11585, Carrie and Sheila Irene Revocable Trust.
Here.
Good morning. Are we going forward on your case?
Oh, yes.
All righty. About how long do you think your presentation?
Maybe 20 minutes or so.
20. Okay, to the assessor.
And the assessor is prepared to move forward. We anticipate 15 minutes on this case.
Okay. All righty. That does it for the agenda. So we've got 1, 2,
We got 5 cases moving forward today.
3, 4, 5. Okay. We'll just go in order on the agenda.
Yeah, that's the recommendation. So those of you that are presenting today, you're more than welcome to sit and watch, or if you don't want to sit here, you can go roam around until it's time for your hearing. So we'll be doing Mr. Williams first, Ms. Russell second, Mr. Nalen on Zoom third, and Mr. Glasgow fourth, and the layman's number will be the 5th, last of the day. So each hearing usually takes about 30 to 45 minutes accordingly. Mr. Williams, if you'd like to come around to the table, have a seat. I'll let you know.
Okay, I'll be here all day. Okay.
Pardon me, is there any way you can like call us in the half an hour beforehand or something?
I can try to make a note. Yeah. I'll make a note to try to give you a call when the hearing just before you is starting.
Okay.
Thank you so much. I'll call at the number I spoke with you last week on.
Very good. Where's somebody?
Yeah, just yeah.
First one.
Right there. Okay, so you have to
Huh?
pass some papers back and forth.
Yeah. I think so. He should have a few minutes.
Would you like a recess hearing, Officer Little?
And let's do a 5 minute
Okay.
while we get set up.
All right. All right, we're back on the record.
Okay. Again, this is agenda items 8 through 10, applications 21-10314 through 21-10316. John T. Williams. I'm gonna get a brief overview from the assessor as to the issues, and then it's land, so the applicant will carry the burden of proof, and that determines that you present your case first, and then the assessor will ask you questions. I'll ask you questions, and then the assessor will present their case, and vice versa.
We may not have the same issues.
Oh, okay. All
Yeah,
right.
I think the issues are divergent.
Okay, I'll
So-
come back.
Yeah, we can hear after the overview from the assessor, but I have handed out a copy of the application as well as applicant's exhibits, 1, 2, and 3.
Okay,
Is what we'll call the documents. This is a change in ownership appeal. And then also, we have Keith Williams on Zoom for this item, if needed at all. So we'll turn it over to Mr. Heim for the overview.
The assessment under appeal is the 2021 regular assessment. An appeal of the base year value, and specifically what's at issue is whether there was a change in ownership in the March 19th, 2015 transfer of the subject property. And if so, whether the base year value established as of that date is correct. And the only issue being addressed today is the change in ownership.
okay.
And briefly, Mr. Blahakis, would you like to pass out the assessor's materials now?
If you don't mind, we can pass them out now.
Okay.
You're not planning on presenting yet, right?
No, we'll
Yeah.
be presenting after the
Wait.
applicant does.
We can go ahead and hand those out.
Whenever is the best time to do that.
If you're okay with it, we'll hand them out now. Make
That
it
sounds
easy. Copy of the assessor's materials.
While Brendan's doing that, I'll
Right.
ask
That might be
the
a
applicant,
mistake.
are the issues
Yeah.
the same as with the assessor?
I believe they're different issues. He knows what my issues are, but his points are gonna be different than my points.
Okay, his opinion versus your opinion, but the base problem is the base year value transfer of title on March 19th, 2015, is that
It's
correct?
no, it's not about value. of the
Okay, yeah, it's
property.
only about change in ownership.
Right,
Did it
Right.
change hands? That's
Yes.
the only issue we're looking at.
that's what I was told
Yes.
by the assessor.
Yes.
Excellent.
Correct, and maybe clarify, it's, I don't think there's a question as to if there was a change of hands, it's if it was a reappraisable event as of March 2015 or not. And
Yes.
So, which will, I'm sure will become clearer once the assessor presents their case.
Okay, yeah, so we're not talking about value at all. We're talking about,
Not today.
yes.
I requested that, but
that hap-
as a second step.
Yeah.
But
Yeah.
that's,
Excellent. Okay, go right ahead.
okay, my name is John Williams, and I have a presentation of basically a title mistake is my basic presentation. And this property is referred to as Crocker Fee. We purchased this property in 1999 from Texaco. And my first part is, do you have my,
Yes,
okay. Practice makes easy for the practice title professional and or real estate attorney. Correctly preparing title is easy. For the non-professional trustee who is not practiced or studied in this specialty, title is not easy. And then after 33 years, and I call it the school of hard knocks, title hard knocks, I would not make this title mistake today. Details of title are complicated for me, not easy, but but I know much more now than I did in 1999, 34 years ago, when the mistake was created. There was never intent to make a title mistake. And basically the title mistake is I titled a portion of this property in the Tom Williams Bypass Exemption Trust. And it was unintended. And I made this mistake alone. I was not advised to make this mistake. The Texaco Land Department did not suggest this. I told the Texaco Land Department how to title the property. And no one questioned my instructions, including my mother, my wife, our CPA, or the Texaco Land Department. The instructions received were passed on to the escrow title company, and the grant deed was prepared. The mistake was of no financial benefit. In fact, it was a significant financial negative, and I'll explain why. No one, including Evelyn Williams, the Tom Williams Bypass Trust, or John and Cindy Williams, benefited from this mistake. John and Cindy Williams purchased these lots alone, entirely funded with our own money from John and Cindy Williams. And the number 3, in 1999, I did not understand that this was a big mistake, nor did anyone suggest that it was a big mistake until I received the assessor letter on June 24th, 2021, 31 years later, after my father had passed, and 6 years after my mother had passed, over 6 years after my mother had passed. So I was unaware of this until I received a letter about 6.5 years after my mother had passed in 2015 for the escape assessment. Okay, the lots closed in 1999, 9 years after my father's passing. And I'm not making a point that this is a parent-to-child transfer. When we recorded this in 2015, after my mother passed, all proper forms were submitted to the recorder, requested documents, declarations, certificate of trust, acknowledgements of trustee, and the complete Tom Williams and Evelyn Williams trust dated 1988 were submitted to the recorder office in 2015 when the parcels were transferred to John and Cindy Williams Family Trust. Title correction could have been made at any time during those years, approximately 24 years, I believe. I'm not sure the exact number. But I did not know to make a correction, nor did anyone tell me or advise my family that there needs to be a correction of this mistake. Number 7, why did I make this unwise mistake? Basically, I was not advised by anyone on how to title this purchase, and I was naive about the possible consequences of a mistake. The title language was imagined entirely out of my love for my father, who held such great love for me. In my mind, it was an honor of his memory alone. No property tax consideration was made because I naively believed this was a family ranch property and there would be no property tax reassessment. On number 8, I maintain that the Tom Williams bypass exemption tax returns do not demonstrate that the Tom Williams bypass exemption financially benefited in any way Or did the Williams family? Because this is vacant land and it's all expense. It did not benefit the trust, did not benefit my mother, it did not benefit my wife or myself. John and Cindy Williams funded all the property expenses and property taxes, plus trust returns are an added professional fee. So there was no financial benefit to this at all of CPA fees per year to prepare these returns. And they are also taxed at a higher rate than a joint return between a husband and wife. There was no benefit. And so the point is overall the titling in this way, which was a mistake, was a major net negative for my entire family. It never should have existed. And I also want to make the point that the bypass trust or the AB trust was marketed to my parents and people like myself by legal professions to lay people who really don't need an AB trust. And that's the root problem of this title mistake. First, I made a mistake, but just having the AB trust is a mistake in of itself for our estate personally. Federal tax laws are fluid and change on a regular basis, and attorneys change their advice annually. Today, I would never have an AB trust or set this type of situation up even happen. And CPAs can't really advise me or my family because they cannot legally give legal advice. But the CPAs make good money on the bypass returns. So lay people in the 80s and 90s were generally ill-advised by estate attorneys, probably well-meaning, on the benefits of an AB trust. And I assume everybody here understands what an AB trust is, because you're all professionals. Average people were not told that the AB trust was not right for their estate. And today, no attorney recommends an AB trust for an estate like mine. And today, portability is the recommended buzzword. So the changing fluid tax laws for lay people who do not have a staff of attorneys or at least one attorney and a competent CPA are ill-advised. Number 11, Tom Williams Bypass Trust did not contribute any funds for the purchase of this property. No depreciation benefited Tom Williams Bypass Trust. The 3 lots are vacant land. There's no depreciation. And when we purchased these 3 lots, no mineral rights came with this purchase. No minerals were transferred in the 1999 land purchase from Texaco to Williams. Later, Texaco held back the minerals at the last minute. Later, they were transferred, but that was through a different purchase. But they were never transferred on this purchase. So the point is that this property came without the minerals. Okay, number 14, in a second deal in 2002 with then Texaco Chevron, when we bought 2 additional lots from the company, Texaco did grant the minerals for all of the property we purchased, but it was owned by John and Cindy Williams. It was never owned or in the bypass trust. And number 15, no cattle income or payments were ever paid to the Tom Williams Trust. All the cattle were owned by John or Cindy and or family members. No cattle payments. And regarding the grazing rental, no rental was ever paid to the trust. No rent was ever paid to the trust or by the Williams or by others. And number 17, the mortgage interest payments on regarding that, there was never mortgage interest payments. This was an all cash deal entirely funded by John and Cindy Williams. There was no ever a mortgage interest. And all of the property taxes were paid by John and Cindy Williams. Tom Williams Bypass Trust did not pay the property taxes. And this is just a little map of what we're talking about with the crosshatched area. And this is very rugged land, very mountainous. It was called the Crocker Fee. It was owned by Getty. Has quite a very interesting history if you study title history. People like John Doheny owned it. J. Paul Getty owned it, and it's quite a storied history. But we were offered this property and were able to buy it when nobody else wanted it. And that's like a little map of the next page of where this property is. And these are actually patented claims that existed originally, which are slightly different than the assessor parcel numbers. And the last part I wanted to just bring to your attention is this group of documents here, which are our purchase, where the money came from. And when you have a chance, but all of this is our closing statement. And I point out where the mistakes are, but in large part, you can see that all of the money came from myself and my wife, and a significant part came from the sale of our home in Valencia. About this time we purchased this property, and also other money we scraped together to buy it. Tom Williams did not contribute to this. This was totally a mistake. And I would like to, I've mentioned in my notes an accommodation, considering that lay people can make mistakes, and that maybe there was some way to accommodate that mistake.
That concludes your presentation.
Oh, I can answer questions.
Are there any questions from the assessor to the applicant?
Yes. So did you ever consider the bypass exemption trust an owner of the property?
No.
A part owner?
No.
So
it was a mistake because I explained that it was simply honoring my father. And when my father passed away, it was not a large insurance policy, but it was enough to help buy our home in Valencia. My mother was the beneficiary. We bought the home in 1990, and that insurance money helped us make that purchase. So 9 years later, we buy this property with the sale. Now that house was not ever titled in my mother's name. It was titled only in my wife and myself. So we owned it 100%. And when it was simply a naive mistake on my part.
Okay.
And
why?
And of course, land does not generate any income.
Why did Evelyn L. Williams and as well you, I believe, as both of you as trustees of the bypass exemption trust, if you did not consider that trust an owner at any time, why did you continue to report the property on the income tax returns for that trust?
We didn't know there was a mistake until you wrote me that, or not you, Efren. Efren was originally on this. I sent him a letter a couple years ago. But we didn't know there was a mistake.
But
And the fact that over 6 years have gone by after my mother's passing, we didn't know there was a mistake until we got the letter.
I guess my question is actually if for the tax returns for a trust that did not own a property, if you did not think of that property as owned by that trust, why were you reporting that property on that trust?
Because we believed we were correct in titling it. It was not a professional, there was no professional thinking going on here. This is all family. My mother, who doesn't know anything about this stuff. Myself, who knows very little, and my wife, who maybe knows a tad more than my mom.
All right.
And my CPA, who is pretty much doesn't make legal advice because he doesn't have authority to make legal advice because he's not a lawyer. And my trust attorney, who became my trust attorney, didn't even know there was a mistake. How would he know a mistake? That he wasn't advising us on this purchase.
So I guess in your mind, the trust, there was just confusion about whether the trust had any ownership.
If anybody would listen to this story, who's a professional, it's embarrassing, but it's real. People make mistakes, and no one advised me to make this. It was solely myself.
All right.
And I'm like all this work, you know what much work is. I don't get paid to do this.
Could you repeat question? I just wanted to point out that on the applicant's presentation, the case numbers.
I know I made a mistake on the case numbers.
Oh, okay.
Yeah, I saw that
Okay.
Yeah, I saw that 1-4 instead of 1-7.
Yeah. Yeah. So the series is 4, 5, and 6 rather than 5, 6, and 7.
Yeah, I saw that.
Just so that we have that.
Thank you for
noted.
pointing that out.
And that will be, I'll apply the hearing officer in order to cases that are agendized today, so we,
That's it.
My question is, has the mistake been corrected now? Have you changed the title?
Well, what happened was my mother passed away in 2015. I didn't know there was a mistake. And I was believing that wrongly again, parent to child transfer. I just totally misguided myself. And then my wife passed away in 2019, and we transferred it. Well, when my mom passed away, we put it in my wife and my trust. And then when my wife passed away, I don't believe I did anything. When the attorney, I think, sent death certificates to the county and certification of trust of my wife and my trust. So she died in 2019, and then in 2021, June, we get the notice of the escape assessment. And so that's.
Okay. And the name of the trust that is for you and your wife?
John T. Williams and Cynthia B. Williams Family Trust,
dated August 26th, 1991. And it's an AB trust also, but my CPA, current CPA said, do not fund the AB trust. Do not do that. So I never did that. Don't make that mistake.
And when the mineral rights were transferred, was
They-
there any monetary
No.
fee paid on that?
No, all we did was bought, there were two different lots on the map. Those two lots are right next to the Condor Sanctuary, the National Condor Sanctuary, very rugged land. These two lots here, we purchased. And when we bought those, they granted the minerals for these two, plus they threw in the minerals for this over here.
Okay.
So, and this was bought in my wife's name and my name alone. So we didn't make a mistake here. Just by luck. We didn't make that mistake.
Okay. Any further questions?
It wasn't like the minerals were purchased for money.
Right.
They just came with the deal.
Okay. I was just thinking something might have triggered at that point, but it didn't. Okay, to the assessor.
Assessor's exhibits A through F have been submitted.
Thank you.
Caleb Heim for the assessor's office. As I think we've talked about to some extent, on March 12th, 1999, the grant deed was recorded granting legal title to the subject property to the following grantees as to the following ownership interests: 60% vested ownership in the Thomas B. Williams and Evelyn L. Williams Trust, also called the Tom Williams Bypass Trust or the Residuary Trust. 20% vested ownership in that same trust, but the portion of it called the Survivors Trust for benefit of the surviving spouse. And 20% vested ownership in the John Williams and Cynthia Williams Trust. The trust that the applicant referred to earlier. As we know, Thomas and Evelyn Williams are the parents of the applicant. Before the March 12th, 1999 acquisition of the subject, Thomas Williams had passed away in February 1990. And upon Thomas Williams' death, his and Evelyn's trust split into the Residuary Trust and the Survivors Trust, with Evelyn Williams as the present beneficiary of both of the trusts, and the applicant as the future beneficiary of both trusts. That means that Evelyn Williams owned the present beneficial interest in any property held in the Residuary Trust and in the Survivors Trust as of the 1999 purchase of this property, the subject property. And then in March 2015, Evelyn Williams passed away. And the present beneficial interest in the property held in the Residuary Trust passed to the applicant at that time. So whatever present beneficial interests Evelyn had in whatever property the Residuary Trust had at that time in March 2015, all of those interests passed to the applicant. So a change in the present beneficial interest in property held in a trust is a change in ownership of that property unless an exclusion applies. The present beneficial interests in the property held in the Residuary Trust, the Bypass Trust, changed on March 15th, and so that's a change in ownership unless an exclusion applies. And we're in agreement that a parent-to-child exclusion does not apply in this case. In the change in present interest in the Residuary Trust as of the death of Evelyn. So that's not an issue in the appeal today. What is at issue is whether Evelyn Williams acquired a present beneficial interest in the subject as held in the residuary trust in the 1999 transfer. The residuary trust acquired legal title to 60% of the ownership interest in the subject in that transfer. And if Evelyn Williams acquired a present beneficial interest in the 1999 transfer in the subject as held in that trust, then that present beneficial interest changed ownership as of her death. If she did not acquire a present beneficial interest in the 1999 purchase, then no change in ownership of the subject as held in the residuary trust occurred as of her death in 2015. So the question is we know that the bypass trust, the residuary trust, acquired legal title to the property in March 1999. The question is whether the beneficial interest holder in that trust acquired any beneficial interest in that property as of that date. The assessor's determination is that Evelyn Williams acquired a present beneficial interest in the March 1999 transfer in the subject as held in the residuary trust, and that therefore this present interest changed ownership upon her death in 2015. And the reasons for the assessor's determination are the following. So we're on page 4 of your packet there. Number 1 of the assessor's determination, the residuary trust reported the subject on its income tax returns and received income tax deductions attributable to the subject. An owner of rental property may report the property on its income tax return and receive an income tax deduction for rental real estate loss attributable to that property. During the 17 years the residuary trust had legal title to the subject, the residuary trust reported the subject on its income tax return for 15 of those 17 years, including the first 5 years and the last 5 years of legal ownership. And we can look at that in the income tax returns if we want to do that. The residuary trust received an income tax deduction for 12 of the 17 years for a total deduction of about $33,000. And we can see that on page 33 of your packet, there's a chart showing
Which page?
33. Showing the reported numbers summarizing the reported numbers from the income tax returns. Number 2, Evelyn Williams, as present beneficiary of the residuary trust, received a present benefit from the subject as held in the residuary trust from March 1999 to March 2015. Receiving income tax deductions attributable to a property constitute evidence of present beneficial interest in that property. From the March 1999 acquisition of the subject by the residuary trust to her March 2015 death, Evelyn Williams, as present beneficiary of the trust, consistently received income tax deductions attributable to the subject as held in the residuary trust. Therefore, the assessor determined that Evelyn Williams acquired a present beneficial interest on March 12, 1999 in the subject as held in the trust, which she enjoyed until her March 19, 2015 death. The transfer of the present beneficial interest, point 3, of the subject as of Evelyn Williams' March 2015 death was a change in ownership. On March 12, 1999, Evelyn L. Williams acquired a present beneficial interest in the subject as held in the residuary trust. Upon her death, this present beneficial interest transferred to the applicant. The transfer of the present beneficial interest in property held in a trust is a change in ownership unless an exclusion applies. No exclusion applies to the March 2015 transfer of the present beneficial interest in the subject held in the residuary trust. Therefore, the transfer of the present beneficial interest in the subject held in the residuary trust is a change in ownership of the residuary trust's 60% legal ownership interest in the subject. And in conclusion, the assessor requests that the Assessment Appeals Board sustain the assessor's determination that a 60% change in ownership of the subject occurred on March 19, 2015.
Galen, do you believe the fact that I paid and my wife paid 100% for this property makes any difference in beneficial? We call it present beneficial. I paid for that property along with my wife. My mother did not pay for this property.
That is true.
There's no beneficial benefit for her because on a joint return, tax rates are lower. We paid higher tax rates on a trust return than a joint return. So there is no benefit. My mother did not enjoy a benefit. There's no benefit on vacant lots in the mountains. So legally, you may be arguing a structural technical point, but the reality is I paid for this property along with my wife with our own blood, sweat, and tears, not my mother. My mother helped me buy a home almost 10 years earlier through my father's life insurance, which was a benefit. But the reality is that the home sold for less than what we had paid for it in 1990, in 1999, because of recessionary factors. So the money we received was all equity that we had put into the property through our payments. My mother did not receive, this is all honorary. And if that's what I'm requesting, that there needs to be some accommodation for mistakes that are stupid. And that's what this is. We're not talking like we're professionals here. You're a professional, but I'm not. I'm a layperson. I made a mistake. And that's my main point, that she did not receive. I mean, to say that she received benefits is like, really? This is a benefit? I don't see the benefit. I paid these taxes. I picked up all the shortages. And she didn't receive any benefit.
Okay, I'm just step in here. Does that conclude your presentation?
That concludes the assessor's presentation.
Okay, so I'll look at that as a question. Your evidence to show that Evelyn had beneficial interest, would you explain that once again?
The information that we have from the applicant indicates that the trust in question that had legal ownership reported the property on its income tax return and received an income tax deduction for that property. That having legal title and receiving a present beneficial interest is what constitutes an ownership interest. So if the property is owned by the bypass trust, the residuary trust, the assessor and the present interest in the trust changes, then legally that is a change in ownership. And that is the determination that the assessor must go with.
And is that regardless of who paid the money for the property?
Yes, because each of the components of exercising beneficial interest can be separated. And what we would need, or what would need to be shown, that a legal title holder to a property was not actually an owner is that none of the components of receiving a present beneficial interest were attached to that owner, to that legal title holder. And in this case, the components of present interest are divided among the different legal title holders, which is actually much what we would expect if there are multiple legal title holders who hold varying amounts of interest concurrently, that they would each receive some amount of benefit. And whether they receive proportional benefit to their legal title interest is not actually relevant to the assessor's determination of a change in ownership. The questions are who has legal title, and do they receive any beneficial interest in addition to that legal title? And the presumption, according to property tax rule 462.200B, is that whenever a name appears on a deed, the rebuttable presumption is that that person has an ownership interest. And so to overcome that presumption, it would have to be shown that person has no beneficial interest at all in the property, just this legal title. And the assessor's determination is that that is not shown in this case. So the assessor must go with the rebuttable presumption that everyone's name that appears on the deed is the name of an owner. And that means that there was a change in ownership as of Evelyn's death.
Okay, and on the beneficial interest, it sounds like it is not a multi-pronged situation where you have to pay the taxes. You can report it on your tax returns, purchase the property. You don't have to have multiple situations to determine the beneficial interest.
Yes.
It can be just one simple item,
Yes.
such as receiving the depreciation on your tax return.
Yes.
That kicks it in.
Yes, because because having that, and because if one has legal title and then one does any of the things that legal title entitles one to do, then that is having an ownership interest.
It's really easy to slip into technical jargon and slip into technical thinking. That doesn't apply in this case. It was a mistake. And there were 16 years of opportunity to back this out. If somebody had told us, rich people have attorneys that would say, fix this. If they have good CPAs, they would say, fix this. So lay middle-class people are rolled by these technical traps of the AB trust that have existed, and they are throughout your title records here, because these AB trusts are all over the place, and they're just traps ready to catch people like myself. Not too many people would make this mistake. I would say this is a rare mistake, and I think because it's such a rare mistake, there needs to be an accommodation, a pathway to correct the mistake by talking purely technical mandates that apply in not a way that should be applied in this case, because my wife and I bought this property with our money. My mother did not benefit from owning this land. These numbers, I would have to have a CPA look at them to see if there really is any beneficial benefit there. I don't know that there is. I don't know how you did that, but you did.
Okay, right now in the hearing, the assessor made their presentation. I'm looking for questions for the assessor. You will get a time for rebuttal
Right.
closing remarks.
So
but-
basically what we're saying is, what you're saying, Caleb, is that I made a gift of $251,000 to my mother without reporting it to the IRS. That's what you're saying.
I would not.
Because
say
I made a
that.
gift then, because you're saying that I put $251,000 in my mother's name without reporting it as a gift. You know, you only can give, back in those days, 10,000 per year. So why the IRS didn't get a report that I made a $251,000 gift to my mother, because it didn't happen. And she did no interest in beneficiary. She is not a beneficiary of this. Technically, you're arguing mechanical aspects. The reality is we want to back out, find a pathway to back out a mistake.
Okay, your response is.
The assessor
You
is,
did not make a
is,
gift.
the assessor is only saying that the data show that there was a change in ownership as of March 19, 2015.
Okay, I have a question. Why does the parent to child transfer exclusion not apply?
Because
I actually purchased this property 9 years after my father passed away. That's why
yes,
I misunderstood that too. That was another mistake. But since it was 9 years after, and my parents didn't own this property before my dad died. So
the reason is that the trustor in an irrevocable trust is the transferor in transfers of property in that trust. But so that means that as of Evelyn's passing, the transferor and the transfer there from, even though the present interest transfers from Evelyn to the applicant in that transfer, the transferor is Thomas. But Thomas never owned the property because it was purchased after his death. Therefore, the property oddly is it is transferred by someone who never owned it. So then we can't apply the transfer to, or we can't apply a parent-to-child exclusion to a transfer between Thomas and the applicant because Thomas never owned it. And we can't apply it to a transfer between Evelyn and the applicant because Evelyn's not the transferor.
my point is that these subjects are so complicated. And we're getting into an area right now that, quite frankly, I don't know that anyone knows the answer correctly. So we're talking complicated, but I believe you're correct on what you're saying, but I don't know that's 100% correct. But I do know that the money, the 251,000 was put into the wrong trust. If I had put it into my mom's title, it would have been, we wouldn't be sitting here right now. But I made the mistake because of this AB trust split that somebody created and attorneys sold. I put it into the wrong basket. And my emotional reasons really probably aren't the county's concern, but they're real. But so if I put it over in this basket, we wouldn't be sitting here. But I put it in the wrong basket, and that's why I'm saying that there should be a pathway to correct this mistake, and not just a technical 462.200 issue that we're dealing with here. So it was put in the wrong place. And I didn't make a $251,000 gift to my mother without reporting it to the IRS.
Are there any further questions? Are any further questions of Caleb and his presentation?
This is a more this is rare, but it could come up again sometime. But when you find somebody like me who makes a mistake and doesn't have the proper advice, and so I'm thinking that accommodations need to be made for honest, unintentional mistakes.
Okay, I'll turn that into just a different angle. Does the assessor or the hearing officer have any jurisdiction to change the way that this situation has occurred?
The assessor certainly has no jurisdiction to do so. We would have to refer you to county council to consider your jurisdiction to make or in what determinations you would be able to make.
Okay, and on your presentation on the page 33, the amounts that have been
Where did those come from?
That's from IRS tax returns.
Those are, that is a summary of the same numbers that are in Exhibit F.
That stuff.
Yes. And they're just all put together in one table
Okay,
for just this property.
okay,
And okay, that would be, we'll reserve the next thing for the assessor's closing.
okay. And closing, we'll have the assessor do their closing first.
Yes.
And let the applicant give his closing last.
The assessor doesn't have any more particular large conclusions to mention other than that the assessor has followed the law in accordance with the facts and has determined that there was a change in ownership as of March 19, 2015 of 60% of the ownership interest in the property. A few other points to mention. First, even though the property was perhaps a net loss for the Tom Williams Trust as indicated, even in the assessor's table in Exhibit E, that still allows for an income tax benefit exercised by that trust. And because there is a deduction for rental loss, and having legal title and taking an action that an owner can take is exercising a present beneficial interest. Having a present beneficial interest and exercising it is evidence of being an owner. It also, and it's not entirely clear what tax is being paid by the Tom Williams Trust as reported in the income tax returns, but some tax is reported as being paid connected with this property. So it's not abundantly clear what tax that is, but it might be, it may be property tax paid on this property by the trust. So it's not abundantly clear that only the applicant paid property tax on this property. And then to sum up, the assessor has followed the law in determining what the change in ownership status is, and would reiterate that the grant status is a mistake, doesn't affect whether the property was, or whether an ownership interest was granted to the bypass trust, or whether the bypass trust exercised an ownership interest. And both of those things occurred. Like the grant was recorded, granting 60% ownership interest to the trust, and the trust exercised an ownership interest. So there's nothing more that would need to be shown to show that there's a change in ownership as of Evelyn's passing.
All right, closing by the applicant.
Well, I'd like to find a problem solver and not ones that's focusing just on technical. And it was a mistake clearly made, it was an honest mistake, and the basket that it was put in, the 251,000, was in the wrong basket. And it was the wrong mistake, the wrong words were said. And this is not just affects 1 year, this affects the rest of my family's existence, because this is a legacy property, and it's to hold on property like this for a family becomes quite burdensome if the taxes are unreasonable on land like this. And we bought the property when nobody wanted it, and now it's being changed due to a mistake. And I just want to find a solution to this that maybe the legal counsel can look at, maybe find a little box in the rules that we can't even imagine in this room that say, when you have people who don't know what the hell they're doing, we can help them out a little bit. And that's where I think I am. And I appreciate it if maybe the legal counsel could take a look at this and not just look at it from a technical standpoint, but from being a problem solver and
Appreciate it. All right.
thank you, Caleb.
Thank you.
Thank you. All right, at this time, I will take the evidence submitted, the testimony as stated, and I will deliberate after the other hearings, and if need be, I will discuss this with county counsel's office. Brendan will notify you as to my decision.
Thank you.
Thank you.
Thank you very much.
Thank you,
If you
Brendan.
want your folder back.
Oh.
Yeah, if you want the. Here you
Now, as far as the value,
Oh, no, as far as like a 5-minute recess.
sure, you got it.
Oh, you know.
I
that is-
hope we never have to do this again.
Mr. Williams, that's a good point. Ms. Little mentioned the second part of this hearing on the value. So would we like to schedule that for October 23rd?
Am I conceding the beat already?
No, in the event,
No,
so
no,
if the
no.
hearing officer decides in your favor, the.
The 25th, the 24th is fine,
Okay.
or the 23rd.
23rd.
Okay.
Yeah.
Okay, so we
Value.
will continue the value portion on the 23rd.
All right,
Excellent.
Thank you, Mr. Williams.
okay. And we're taking a brief recess?
Yes.
Okay.
Get the next one set up.
While we're in recess, whoop, just a moment.
Is there somebody there I can talk to?
Brendan, do you want to mute everything?
Thank you. Mr.
Hello?
Sullivan, are you there?
Yeah, I'm just trying to get I'm coming back from the airport. My flight got delayed, so
Got
I'm
it.
just trying to get an extension for my appeal.
Yeah, that's why we're during the break. I was gonna talk to you. The hearing officer denied your case because you weren't present, but it's my understanding that the assessor offered you a reduction and is just waiting to sign paperwork back. Are you disagreeing with the reduction from the assessor?
I'm coming to the county government center in about 15 minutes. Can I get a copy of that?
Okay, so you wanna, so if you wanna stay on the phone, what we need to do is reopen your case, because it's been denied, and then I will let, Joe Vernon know you're on your way here. He's the person
Okay.
who's emailed you that, and he could possibly work with you to get that signed.
I don't think he has my right email address, so I'll look in my spam folder.
Okay,
I-
I'll let him know, but
I'm
you're
right-
on your way here in person, correct?
Yes, I'm right here in coming past Central, so I should be there pretty quick.
Okay, well, yeah, no rush, and you can, get your case reopened by phone, so just stand by and we'll address it shortly, all right?
Okay, no problem.
All right, we are back on the record, and we have some, before we get to the next hearing, do you want to take care of some administrative matters?
Yes. go
Okay,
ahead.
so we have item number 30. Let's see. Item number 30 was denied due to lack of appearance. That's for 22-115-11054 Douglas Sullivan. He has now called in. So Mr. Sullivan, if you can go ahead and press star then 6 to unmute.
Yes, I'm getting out Victoria.
All right.
It should be there in
Okay.
5 minutes.
All right, first we're gonna ask the hearing officer to rescind the denial.
So ordered.
All right, and then we would need to let's see. As this case was not confirmed, we'll need to reschedule the hearing to October 23rd. Is that all right with you, Mr. Sullivan? Mr. Sullivan, are you okay with rescheduling?
I couldn't hear that last part. What did you say?
Yes, so because we did not receive confirmation at least 30 days prior to today's hearing, you'll be required to reschedule. Are you okay with October 23rd?
October 23rd would be good, yes.
Okay.
To the assessor, are you agreeable?
The assessor is agreeable with the continuance. I would like to ask the applicant, after speaking with the appraiser, a preliminary stipulation was mailed to the applicant or emailed to the applicant. Mr. Sullivan, did you receive a stipulation from?
I'm driving right now. I'm gonna try to. I have not seen the email, and I check my emails every day, so I've not seen what the guy that was speaking before sent me an email requesting some documents. I never got that one, and I never got the reduction proposal.
Okay. Well, we can work it out. We have time now.
Okay, the assessor will reach out and.
Yeah, it's my understanding you're on your way here now, Mr. Sullivan, correct?
Yeah, I just got the freeway. I'm on Victoria in the 101 right now.
So I let the appraiser send your case, Joe Vernon, know that you were on your way in. So if you just want to go straight to the assessor's office, you can review with him the documents that were emailed to you.
Yeah, I'm already up here. Yeah, that's
All right.
correct.
So in that case, Mr. Bates, you needed a data proviso is just a continuance. All right.
Just a continuance is fine. Yeah.
All right. So hearing officer, for your sake, we just need to continue to October 23rd, and then when Mr. Sullivan goes to the assessor's office today, stipulation that will cancel the second hearing.
Right.
Okay.
Okay, very good.
It may be a moot point to continuance once I find out what the proposal is. So,
right.
I'll be there in a little bit. Okay.
Okay. Very good.
All right. Thank you.
So ordered.
Okay. Thank you, Mr. Sullivan. You're all set. And then we also, we had a few administrative matters come up. Item number 20. Application number 22-10740 for Alon and TB. That's another one that was denied due to lack of appearance on agenda review. It was determined that a stipulation was signed and submitted last month, and it just hadn't made its way through the process. So the taxpayer can get that reduction. Recommended action would be to make a motion to vacate the denial due to lack of appearance and continue to October 23rd, pending receipt of the original stipulation.
Okay, what agenda item was that?
20.
20, okay. And that's application 22-10740.
Correct.
Okay. So ordered.
All right, just a moment. And it does look like we have one other case that was denied that is now in attendance. Give me just a moment. All right, so the next we also have item 11, which is application number 21-10335 for N92714 LLC, and we have Brandon Hanson on Zoom for this item. Would you like to start by vacating the denial, or would you like to hear from the applicant as to their reason for non-appearance first?
I'll listen to the applicant first. Can you hear us now?
I can. Can you hear me?
Yes.
All right, Mr. Hanson, real quick, before you speak, I'm gonna place you under oath. Please raise your right arm. When I complete reading your oath, please state I do. You solemnly affirm that the testimony you're about to give and the matters now pending before this hearing officer will be the truth, the whole truth, and nothing but the truth.
Yes.
Thank you.
Okay. You're not present here today and you weren't present at 9:30.
No, I had a work emergency this morning and I could not get to the computer.
Ready? And so you're not prepared to go forward on your case today? Or you are?
I certainly can go forward today. Originally, I was trying to request an extension, but that sounded like that wasn't an option. But I have just a few items that I don't need to turn in, that they're a part of the case already that I can go over. I was not able to get my comments back from my attorney or CPA yet, but I can do my best here this morning if that's what we need to do.
Okay, I'll look to the assessor. Are you prepared to go forward today?
So I would just like to mention this case was heard here in the hearing officer back in February. Our appraiser had already presented the case. The applicant already presented his case via Zoom. A continuance was granted at that time so that the applicant could provide our office a copy of the flight logs. It's my understanding that as of today that we have not received those flight logs. Mr. Hanson, is that, do you have a copy of those available? The flight logs that were requested?
As I mentioned to Araceli, they're not, I mean, I don't have flight logs. It's a private aircraft, and the only way to get flight logs is to try and get the various pilots to recreate something out of their logbooks if they happen to have logs. We're not a commercial this is not a commercial airplane. It's used by private individuals, and there isn't any good way for me to provide that without significant information from the other folks. And I have not been able to get that yet.
Yeah, so the applicant had agreed at that time for the
Right.
continuance to provide it. So without those flight logs,
I have other pieces of the puzzle besides flight logs that I would like to go over if we're going to move forward with the hearing.
So I just note for the hearing officer, I don't know if you agree if good cause for continuance has been met or not, but the 2 years to resolve this case expires on August 18th, so a little bit over a month from today. So we would legally not be permitted to reschedule this without a waiver. Mr. Hanson, I did email you the waiver form last week, but as far as I can tell, that was not signed and emailed back. Is that correct?
We did that on Friday. No, I have not signed and sent it back. I mean, I kind of got the impression from you that it wasn't likely to be granted.
So hearing officer Little, if you want, we can add this to our list of hearings for the day, or you can grant a continuance if we get a waiver, if you believe good cause has been met.
I know we had some major issues on this one, the last hearing, so I am concerned with continuing. Let's set it for hearing. I can accept verbal testimony to the assessor. Is the appraiser of record available for hearing at the end of, we have 4
Yes.
other cases going forward?
the appraiser was available this morning at 9:30. I would just have to confirm that she'll be in for the remainder of the day.
Okay,
So if we put this after our next cases, we'll have time to follow up
Yes.
and get the appraiser back and
Yeah.
get everything prepared.
let's do that.
Okay, so Mr. Hanson, just stand by and we'll come back to your case after some other cases.
Okay.
All right. So hearing officer Little, we're now at item 16.
All right, thank you all for your patience.
It's an unusual day that we have more than 1 or 2 cases moving forward, so we apologize to everybody that's waiting your turn today.
Okay, this is agenda item 16. Application 22-10363, Merrill Russell.
I've handed out a copy of the application, Assessor's Exhibit A, this one exhibit, and then the applicant's Exhibit 1 as well.
And it's a single family resident.
The single family residence challenging the value as of October 28th, 2021. And so the assessors, as they'll cover, they have the burden of proof.
Assessor expert. Okay, that determines who presents their case first.
Correct.
Okay, go right ahead.
Audrey Ramirez for the assessor's office. This is a base year appeal for the subject property located in Camarillo as of the October 28th, 2021 data transfer. It is a single family residence, which is owner occupied. Therefore, the assessor does have the burden of proof. The subject is a tract SFR in Camarillo, was purchased, like I said, on October 28th, 2021 for $696,000. The purchase price was not accepted as fair market value, and instead a value of $920 was enrolled. The applicant appealed the enrollment value, stating the sales price is fair market value for the property. The assessor disagrees with the sales price being fair market for two reasons. The first reason, this is not a Rule 2 open market transfer as defined by Revenue and Taxation Code Section 110 and Property Tax Rule 2. For the sale to be considered an open market transaction, the following conditions must be satisfied. Has to be exposed for sale on the open market, both parties seeking to maximize their gains, neither party taking advantage of the exigencies of the other, reasonable time to allow to find a buyer, reasonable knowledge of the property's uses, present and prospective, by both the buyer and the seller, no collusion or love and affection between the parties, and consideration in cash or its equivalent. The assessor believes that the following two Rule 2 conditions were not met. One, the subject was not exposed for sale on the open market. The subject was not listed for sale on the MLS or other listing services to provide to find a potential buyer. And also that no collusion or love and affection between the parties would exist. The applicant is a real estate agent who represented the seller in a previous transaction. The existing relationship between the buyer and the seller resulted in the subject property selling outside of the open market. This transaction also involved the reduction in the transaction value as the purchase price was negotiated down to remove the agent's 4% commission that the seller would typically pay for an open market sale. Rule 2, or reason number 2, the assessor disagrees with the sales price of $696 being fair market value. Market evidence suggests a higher market value based on comparable sales. Property Tax Rule 2B states in part, the presumption, sales price equaling fair market value, may be rebutted by evidence that the full cash value of the property is significantly more or less than the total cash equivalent of the consideration paid for the property. A significant deviation means a deviation of more than 5% of the total consideration. The assessor used the comparable sales method for valuation to determine the fair market value. And there's an error in the date. It should say 10/28/21, not 10/2/21. For that change of ownership, the comparable sales method indicated that the subject's sales price deviates from the fair market value by 13% of the lowest value indicated. So for the assessor's valuation, the appraisal of the subject property indicated that the purchase price of $696 is not fair market, and that the estimated fair market value is approximately $800,000. Again, previously $920 was enrolled, but based on our valuation, we're now stating $800,000. As the subject was not listed on the open market for exposure, there was current photos of the subject were not available. So the subject did previously transfer in 2017 And after being remodeled and updated, and the listing photos were still available to use as reference, taking into consideration 4 years of typical wear and tear. So that is part of our presentation in later pages. The preliminary change of ownership report, or P4, was provided to our office and signed by the applicant, stating the home was in good condition. Also provided that as part of our presentation. And as this could not be confirmed by a current listing, the subject was estimated to be in average condition and appraised accordingly. There were limited comparables from the same track as the subject that are similar in size, that also sold close to the subject's transfer date, that a market adjustment would not be warranted or applied to the purchase price. Therefore, the appraisal included 3 comparable single-story tract homes from competing neighborhoods that were less than 0.5 miles from the subject, and are all comparable with lot sizes. If you want to reference the appraisal that was done, while I go over it, that is on page 13 of our presentation. Comps number 1 and number 2 are in similar average condition, as they have comparable updatings or lack of superior updating like the subject property. Comp number 3 is considered to be in higher average condition and is adjusted downwards for having superior updates done throughout the home. Comp number 2 is slightly larger than the subject, with a larger garage and adjusted downward to reflect the superior differences. Other adjustments were made for differences in exterior miscellaneous improvements, such as porch and patio sizes that were different than the subject where they were applicable. The transfer dates of the comparables also encompass the October 28th, 2021 transfer date, and no more than 2 months prior or 2 months after. And the adjusted value range was between 800 and 860,000. The subject's purchase price of $696 falls 16% below the lowest value indicator of the comparables used and is not accepted as fair market value. Based on the lowest value indicator, the estimated market value of the subject as of the October 28th, 2021 change in ownership is $800,000. Our conclusion is the assessor initial enrollment of 920 as fair market value was based on an error in the comparables used and is excessive as an estimated fair market value for the non-Rule 2-10-28-21 transfer. Based on the assessor's updated appraisal of the subject, the purchase price of $696 is still far below the market value of comparable properties, and an updated fair market value of $800,000 is estimated as of that October 28th, 21 change in ownership transfer. We request that the Assessment Appeal Board enroll $800,000 adjusted market value as the new Prop 13 base year value as of that date of transfer. On page 4, you can see the preliminary change of ownership report that was reported with the deed. And on page 5, you can see that the applicant indicated that the condition of the property at the time of sale was good, with her signature and date of that signing. Pages 6 through 12 are from the 2017 transfer listing. Like I said, at that time of that sale, it had been updated throughout the home. On page 13, it is our market evaluation showing the adjusted value range from 800 to 860,000. And then on pages 14 through 29 are the listing photos of the 3 comparables that we are using for our comparison. And on page 30, it is a map of where the comparables are to the subject property. And that concludes my presentation. Okay.
Are there any questions from the applicant to the assessor regarding their presentation?
Yes, on comp number 1. The square footage is 1547. The subject property is 1492. You don't make any adjustment for that?
No, it's about what, 15, or like it's less than 100 square feet. They would be considered comparable.
And what about the bedroom? It's got an extra bedroom.
We base it on square footage. Bedroom count isn't something that we typically make an adjustment for, as it's typically more of the bathroom count and not bedroom count and square footage of the property.
So there was an adjustment made on the original appraisal for the bedrooms for $15,000. So I'm curious about that.
I can't speak to the previous appraisal.
So somebody who did this appraisal using $15,000 is not something that you would ever do?
It is a typical office practice that we do not make adjustments for a bedroom count and only for bathroom counts.
So if it was 5 bedrooms, it would be a comparable home if it was a fairly similar square footage. Is that your opinion?
I would say it is something that we don't typically see a market adjustment being warranted for with regards to square footage. Typically, it is the difference in bathroom count and not necessarily bedrooms, as they can be used for different purposes.
Okay, I would have to go on record saying that I completely disagree with that, especially based on this appraisal. And as a real estate agent, bedrooms are much more important than bathrooms. You stated that a typical real estate commission is 4%.
No, that's not what I stated. I stated your commission of 4% was deducted. So that was
You said a seller would typically pay for an open market sale 4%.
commissions. No.
That's
You read what I
read.
said.
I'm confused.
Yeah, go ahead and read that again. I said your commission of 4% was deducted, which a typical buyer would pay commissions for. Commissions
So you're
vary.
not stating what the amount is that what I'm understanding?
I'm not
I'm
stating
not-
what a typical
Where you said a seller would typically pay.
commissions, correct, on a listed.
Okay.
So you provided that your commission is 4%.
Correct.
And I'm stating that a typical seller would be paying that agent commissions.
Okay, that's not how I read it, but as long as you explained it that way, that's fine. I think that's all. That's all my questions.
Would I just be able to follow up on the question regarding the bath or the bedroom adjustment? So that is correct that we don't typically adjust for that. The 15,000 from the original appraisal was for the bath. So that was an adjustment for the bath,
Okay.
not the bedroom. And since the TLA adjustment, the size adjustment is an auto adjustment on our system, and it doesn't adjust for anything under 100 square feet.
Okay, thank you. Appreciate that.
Any further questions?
No.
Okay, we'll hear your presentation.
Okay. I'm Meryl Russell. I've been a realtor in Ventura County for almost 20 years. I purchased the subject property in the Montalena tract in Camarillo in 2021, as you see, and I have quite a few papers for you to go through my presentation. I've tried to organize them so you can follow. The first couple pages are photos of the subject property and the MLS report, as she mentioned, from the 2017 listing. I created 3 appraisals that I'm going to go over, and I stapled them separately, and I'm going to go over the details of all the appraisals. In August of 2021, I had a listing appointment with the owner. The house needed work because it had damage from their 2 large dogs. The paint was not in good condition, nor was the carpet, and the house had a very strong foul pet odor. I knew that putting the house on the market in this condition would not get them the best price. The sellers were in their 90s, and they were not comfortable allowing contractors into their home because of COVID, so we did not get any quotes to make changes to the home. The seller was very knowledgeable about what the homes were selling for. He watched the real estate market closely, and he took pride in knowing the value of homes. He told me he wanted to sell the house for $725,000. We discussed the idea of me buying the home instead of putting it on the market, and he agreed. With regard to the original appraisal, which you have a copy of, Ms. Ramirez did mention that there was an error, and that's probably why we're here today, but I'm still gonna go over my presentation, get my sheets first. So they valued it at $920. To be honest, I'm not sure why it would be $920 when the three adjusted sales prices are $922, $795, and $768. Seems to me, and maybe I understand this wrong, but you would average those three, which would be $828. So that may be wrong. In addition, there was an error on the square footage, and one of the comps did not adjust for the view. The comps that were used were all in the Montelena tract where my house is located. There were 215 homes built in this tract between 1990 and 1995. There were only 8 other homes built in this tract that are model matches to mine with the 1492 square feet. I asked Ms. Ramirez for more information as to how appraisals are adjusted for view, bedrooms, bathrooms, square footage, etc. And I was told that they use a software program, which it sounds like they do, and some sort of cost manuals. And obviously I don't have access to that. So I just did the best that I could on the appraisals that I made. I also did not include miscellaneous improvements on the last 2 appraisals because I had no idea how they do that. It really seems to be coming from the software. The first comp that was used on the original appraisal is 1305 La Culebra. The appraiser made an error in square footage, stating that it had 1391 square feet, when in fact it has 2767 square feet, which is more than double. Has 4 bedrooms, 3.5 bathrooms. This is one of the standard size models in the Montelena tract. There have been no additions to the house to make it that size. And I'll be talking about the other 2 comps on this original appraisal shortly. So I created a new appraisal, and what I did was I took out 1305 La Culebra because it really is not a good comp, being that it's 2767 square feet, and I switched it with another 1824 square foot home on 4740 Via Cupertino, which has 3 bedrooms, 2.5 bathrooms. It's the same floor plan as the other 2 Montelena comps that were used in the original appraisal. This model is the closest in square footage to my home, since they didn't make very many of my particular home. The upgrades on comp number 1 include hardwood floors, plantation shutters, dual pane windows, updated kitchen and bathrooms with quartz counters. It was listed for $749 and sold for $749 in August of 2020. I made an adjustment of $85,000 for the sales date since it sold 14 months prior to my home, and I based this on the original appraisal of the $68,000 that was used for comp number 3, which sold 12 months prior, and $40,000 adjustment that was used for comp number 2, which sold 5 months prior. I also made an adjustment for the square footage and the half bath. In terms of miscellaneous improvements on the original appraisal, $2,000 was used for comp number 2 for the dual pane windows, vinyl plank floors, updated kitchen. $4,000 was used for comp number 3, which has vinyl plank floors, plantation shutters, updated kitchen and bathrooms. So I used $4,000 for the miscellaneous improvements on comp number 1 because it has dual pane windows, hardwood floors, plantation shutters, and updated kitchen and bathrooms. So the price per square foot for this comp number 1 is $424,000 based on the adjustments which I've shown. So I would put the value of my home at $632 based on this comp. The second comp is 4630 Via Cupertino. And I did give pictures and the MLS report. It did not go on the MLS, so it is similar to my situation. This was comp number 2 on the original appraisal that sold for $817 in May of 2021. It has 3 bedrooms, 2.5 bathrooms, and 1824 square feet. Upgrades include a remodeled kitchen and vinyl plank flooring. This was a good comp, except for the error of not adjusting for the really amazing view that this home has. So on the original appraisal, there was an adjustment made for the view of comp number 1 for $48,000. So I used the same adjustment, which brought the sales price down to $747. Price per square foot of $409, valuing my house at $610, $228. And the third comp is 4805 Via Cupertino. The home did not go on the MLS either. And I think that's why the appraiser used those 2, because mine did not go on. This was comp number 3 on the original appraisal, which sold for $760 in October of 2020, 3 bedrooms, 2.5 baths, 1824 square feet, with upgrades of vinyl plank floors, plantation shutters, and remodeled kitchen and baths. After adjusting for the sales gate, the extra square footage and the half bathroom, the adjusted sales price for the original appraisal is $768 with a square foot of 421. Valuing my home at $628, $132. So in summary of my updated appraisal, the average price of my house value based on these three homes is $623, $657. In my discussions with Ms. Ramirez, I understand that she's not going to use any of the Montalena comps, which I'm surprised, but instead of just updating the original appraisal and putting in one that would be appropriate to use, she decided to start over. So based on our discussions, I believe she may be using 5442 Quail Ridge, which I believe did. I put a couple others on Butterfield that she and I have discussed, 5255 Golden Ridge, which she did, and 1176 via Carranza. So I wanted to address these myself. I created an appraisal that covers 6 comps, first of all, that were built in the 1970s and 1980s. So that would include Golden Ridge and Quail Ridge. Then I'll talk about the other one that includes via Carranza after. 5442 Quail Ridge is located in the Mission Del Monte tract. In my opinion, this home is truly an outlier because of the unique upgrades during the extensive remodel of this home. It has 3 bedrooms, 2 baths, 1459 square feet. So very similar in that way. It was completely transformed into a California craftsman style home with hardwood floors, stone fireplace with iron doors and wood mantle. The kitchen has custom cabinets, original Shaw's Farm sink, granite counters, walk-in pantry with glass door, built-in wine storage, custom sculpted backsplash that actually shows the local Topa Topa mountain range. This home has updated bathrooms with custom cabinets, granite counters, tile work, and newer fixtures. They even have dual pane windows, plantation shutters, newer copper plumbing, plus it has solar. And for me as a real estate agent, solar is a huge plus in terms of selling a house. So I don't know if you had added any improvement for that, but to me, that would be a big one. The backyard has newer fencing and above ground spa with a water feature and a fully contained dog run with misters. Truly an outlier. I don't believe this is a fair comp to use. It was listed at $810 and sold for $900. Since Ms. Ramirez suggested using this comp, I did search for others in the neighborhood. And at the time of our discussion, I just quickly looked and I suggested a couple of homes on Butterfield, which are also in the same tract. 5420 and 5322 Butterfield. They both have 4 bedrooms, 2 baths, larger at 1773 square feet. One was listed at $835 and sold for $825 and took 45 days to sell. Which shows that not every house was flying off the market at that time. It has a master bedroom suite where they modified one of the second bedrooms into an office and a walk-in closet. The upgrades include a remodeled kitchen with stainless steel appliances, butcher block island, custom stone fireplace, remodeled master bathroom, dual closets, and a new HVAC system, which is very big. The other one was listed at $799 and sold for $825. It showed nicely with plantation shutters, tile and wood-like floors. I adjusted the appraisal for both of these homes for the additional square footage, and I did a lot for the extra bedroom. So if that's not what you do, certainly my chart would not be 100% correct. The adjusted sales price would be $753,800, which is $425 a square foot, valuing my house at $634. Since then, I found a couple other homes in that area. 1960 Danbury is in the nearby Today Home tracts. And I put the MLS details and photos of that. 4 bedrooms, 2 baths, 1574 square feet. It's got a remodeled kitchen and bathrooms, a tankless water heater, dual pane windows, mirror closet doors, built-in barbecue station, and RV parking. It was listed at $765 and sold for that list price. Price per square foot, adjusting for the extra bedroom, is $466. The value of my home would be $695 based on this comp. And then I also found 5746 Firebird, which is in that same tract very close by. I showed photos, 4 bedrooms, 2 baths, 1862 square feet. Those upgrades include granite kitchen counters, remodeled bathrooms, extended master suite with a walk-in closet. The HVAC system, water heater, and garage door were replaced close to the time that the house went on the market, according to the remarks. The lot on this one is quite large at over 8,600 square feet, and I did not adjust for this because I didn't know how to do that on their software. It was listed at $799 and it sold for $775. It also took almost 2 months to sell. After adjusting for the extra bedroom and square footage, the price per square foot is $368, which would make my home valued at $549 and probably less if the lot adjustment was made. 5255 Golden Ridge is located in the Hillcrest tract. That one has 4 bedrooms, 2 baths, 1547 square feet, has dual pane windows, hardwood floors, and a large lot, which I again did not adjust for the large lot. Listed at $799 and sold for that same price. After adjusting for the square footage and the bedroom, the price per square foot is $500. Value of my home is $746 based on this comp, and I do believe it would be less if the lot size adjustment was made. In summary of my appraisal, the average price of my house value based on these 6 homes that were built in the 1970s and 1980s is $697,510. Now I'm going to talk about the last appraisal that I did, which covers 5 homes that were built in the mid 1990s. That's kind of how I grouped them together, was by the age. 1176 Via Carranza is one that Ms. Ramirez also put on her appraisal, is in the Buena Vista tract. And I put some photos on there also. It has 3 bedrooms, 2 baths, larger at 1639 square feet, and it has a 3-car garage. The upgrades include the brick entry, vinyl plank floors and carpet, updated kitchen with quartz counters, brick fireplace, walk-in closet within the master suite, and a separate soaking tub and shower, and built-in garage cabinets, listed at $800 and sold for $850. After adjusting for the square footage and the extra garage, the price per square foot is $498, so the value of my home would be $743. Since my discussion with Ms. Ramirez, I found a comp at 5151 Corte Vistora, which is also in the Buena Vista tract. 3 bedrooms, 2 baths, 1639 square feet, and a 3-car garage. Upgrades include dual pane windows, plantation shutters, remodeled kitchen with quartz counters and stainless steel appliances, and a separate soaking tub in the master bath. It was listed for $742, sold for $795 at the end of March 21. After adjusting for the date sold, square footage, and extra garage, the price per square foot is $489. Value of my home is $729. I also, in my discussions with Ms. Ramirez, I asked her to take a look at 1513 Alta Vista, which is in the Creekside neighborhood, just across the creek. It has 4 bedrooms, 2 bathrooms, 2,224 square feet, 3-car garage on an oversized lot. The photos make it look okay, but once a buyer walked into the house, it was another story from what I'm told by the buyer's agent. She said it was a mess and her clients had a big project ahead of them. She even offered to send me before and after photos if I was interested, but I didn't want to go that route. I just wanted to use this as a similar type of comp to the condition of the house that mine was in terms of selling a house because of the odor and the paint and the floors. It was listed at $895 and it sold for $835. So this goes to my point at the beginning, since the subject home was not in as good condition as what I normally put a house on the market as, that it might not get top dollar. And I hope you'll keep this comp in mind because of how long it took to sell and how much lower than the asking price. Ms. Ramirez told me that a buyer looking for the home the size of mine would not be looking at a home this large, so she wouldn't take that into consideration. She'd use this as a comp. But I do disagree with that. I believe that whatever amount a buyer is approved for, they will buy whatever home that they want to buy that falls into that range, no matter the size. And larger homes are often better for families moving into these types of neighborhoods. There's also 2 comps in the Adolfo Glen tract that are very good comps to use, in my opinion, on El Capitan and El Corazon. I have photos. These both are 4 bedroom, 2 bathroom, 1816 square feet. Upgrades include vinyl plank floors, shutters, ceiling fans, separate tub and shower, block wall, vinyl fence on a large corner lot. It was listed for $825 and sold for $835. After adjusting for the square footage and extra bedroom, although not for the larger lot, the price per square foot is $415, valuing my home at $619, but I do believe it would be less if you adjusted for the lot size. And then the one on El Corazon, this is the same, 4 bedroom, 2 bath, 1816 square feet with hardwood floors, double door entry, ceiling fans, mirrored closets, wood blinds, and it has a spa. It was listed at $759, sold for $788 in April of 21. After adjusting for the date sold, the square footage, the extra bedroom, price per square foot is 412, and the value of my home would be 614, 704. In summary of this appraisal, the average price of my house value based on these 5 homes that were built in the late 1990s is 611. Even if I didn't include 1513 Alta Vista, which Ms. Ramirez didn't believe was a good comp, the average price on those homes would be 676, 622. Now I wanted to talk about the cost to cure, so that we can accurately compare the house to the homes that I've been discussing. I believe that it's important to compare apples to apples, and appraisals only go so far, especially since I don't have the software to help with the miscellaneous improvements. As mentioned earlier, with the home on Alta Vista Place, not all homes sell quickly and for the best price, and they're not all in good condition. As a realtor, I know when a buyer walks into a house that smells as badly as my house did and needed to be painted because of the dog scratching the walls, baseboards, and the door molding, that it probably would take some time to get an offer, as I've shown on some of the other homes I've discussed. I paid over $5,600 for vinyl plank flooring, another $5,100 for installation. I also paid $3,500 for the house to be painted. Those were just my costs, which were hugely discounted because I'm a realtor and I often refer business to these tradespeople. Would have been closer to $25,000 in my opinion, without the discounts that I was given. I've supplied a copy of my receipt for the flooring from Home Depot. And I also did try to get the carpet and the tile cleaned while I was in there. I tried everything to get the smell out and I couldn't. So that's why I had to replace the flooring and paint. I respectfully requested that Ms. Ramirez take this into consideration. I believe I was given an adjustment of $5,100 for the condition of the house, which I do not believe was enough. I understand that the exact dollar amount paid would not be given as an adjustment. However, as mentioned previously, when a buyer walks into a house in this condition, the price that they're willing to pay is usually significantly less than other homes that are in average or better condition. And I believe this house was priced and sold accordingly. Please keep in mind when reviewing the homes that I presented that my home did not have as many upgrades as many of those homes did. As mentioned earlier, because I did not have the appropriate tools to use in my appraisals, I didn't adjust for miscellaneous improvements. My home may very well be worth less than some of the estimates on my appraisals. I sincerely appreciate you taking the time to listen to my presentation and thank you for your consideration.
Okay, before I ask for questions from the assessor, so the assessor's opinion of value is 800,000.
My opinion at this point, based on what I've done, is the purchase price, it's 96. Yes.
Questions from the assessor to the applicant?
Yes, I have a question. So you stated that the owner came to you to sell the house. You visited the home and you determined that based on the condition of the property, the way that it appeared and the way that it smelled, it would not be good to market it on the open market. Is that correct?
I don't know that I said that. I believe that the condition that it was in, it wouldn't, if we did put it on the open market, I said that I didn't believe it would sell for the prices that the rest of them would in the neighborhood.
Okay. So on my exhibit on page 4 and 5 is a preliminary change of ownership report that gets recorded with the deed that you filled out. On page 5, is that your signature?
It is.
And did you indicate that the condition of the property was good?
I did in that particular form. It's just one of those forms that you fill out in escrow along with 5,000 other forms. And I was just checking boxes. I guess I should have taken that a little bit more seriously and maybe checked it.
Do you understand that this is a form to fill out under penalty of perjury?
I do.
I just have a question or a couple of questions regarding the how the purchase price was negotiated. Was there an original listing price that it was going to be? And then
Yeah, in my presentation, I said that he wanted to list it at $725.
Okay. And that was based, so that's what he wanted to list it at. But was that confirmed with other comps? in the area that would?
We did go over other comps. Unfortunately, I did not print them out. It was a link at the time and the link expired. So we did
Okay.
talk about other houses in the neighborhood.
Okay,
But honestly, some sellers are very strong on what they believe their house is worth. And as a
Okay.
realtor trying to get a listing appointment, I certainly don't fight with them. And that's what he said that he wanted to listen.
okay. Yeah, so I was taking a look at just the appraisals and I do notice that, unlike our appraisal where the dates of the comps are pretty close to the subject's transfer date, there are plenty on here that are older.
But they're within the time frame that is allotted from my understanding on the website.
Right,
And I only chose comps, except for the first one, because I was just trying to keep it to the Mont Helena comps as the original appraisal.
right. But I just can't help but to notice that from 2020 to the end of 2021, the market did change drastically and where I'm just not, I think I'm just trying to pinpoint how we capture that. I mean, that's the main reason why we didn't want to use older comps.
Well,
We
when
did
we went on the
recognize-
listing appointment was in August. It was a very long escrow. So it's not really that much further if you go back a little bit.
Yeah, well, one of the flaws in our original appraisal that we did notice was that we had used the comp a year prior to that. That was in the same district neighborhood. It was larger, but we did want to just keep it. I mean, when you take a look at our comps, they're all point between less than half a mile away. Minimal adjustments on our comps, and just taking a look at the many comps that are on here, there's just a large variety of, I mean, you have older comps, yeah, you do have more newer comps, but
I have a lot of
not
new
seeing.
ones. None of them are old. I did account for I admitted 15,000 for the extra bedroom, which now I'm understanding you wouldn't. So that would be one less adjustment on each. I believe the Mission Oaks neighborhood as a whole,
Mhm.
it doesn't matter if it's 0.5 or 1 mile. Mission Oaks is considered a very popular area for the school districts. So that's why all of those are in the Mission Oaks neighborhood.
I have another question. So previous owner came to you, wanted to list the home for at least $725,000. If you were not interested in the property, to purchase it on your own, you would have at least listed it for $725,000.
I would 100% list it at 725 because that's what the seller told me.
And it is possible that if it was listed on the open market with an opportunity for people to view it in the condition that the property was in, it could have potentially sold for more than $725,000.
I can't say one way or the other. It could very possibly sell higher. It could very possibly sell lower, to be very honest.
So there is a potential,
There's a
if it
potential either
was
direction.
listed on the open market, that it could have generated a higher
It's possible value. It's possible for lower also, based on the condition of the house.
which you had indicated was good on your preliminary change of ownership report after viewing the home. Just wanted to reiterate that.
So I think my question, since the topic of the condition has come up, did you provide Ms. Ramirez with any cost to cure on how much it would have costed to bring that property up to average condition?
Well, I did, and I supplied in here the Home Depot receipt for the flooring,
Okay.
and I gave her a receipt for the carpet cleaning, the tile cleaning. We tried a lot of other things to try to get it right, and the dog
Yeah.
would scratch the paint, the baseboards and the trim around the doors, and
Yeah.
the UPS guy wouldn't even come to my house for months until they realized I was the new owner, because they were afraid of these dogs.
Yeah, but I think just the things that I'm hearing is just kind of more cleaning. I'm not seeing that there's a lot of,
There's no way to clean an odor. You have to replace flooring and paint in order to get rid of a substantial.
okay, so flooring and paint.
And that's all I was asking for in
Yeah.
my presentation was
Right.
flooring and paint.
Yeah, so I think that's just, that was just my big question about the cost to cure. because if we're talking about a property that is less than average condition, and then the issue is more painting and.
You can look at the
cleaning, and
pictures of
it's-
the other one that I was suggesting to you that took 2 months to sell and had a lot of problems with it. You wouldn't know that based on the photos, so. It sold for 60,000 less than asking price. So my request was that you take that into consideration.
Who's the condition?
I don't know if she's making condition adjustments.
I didn't do any miscellaneous improvements because I don't know how to do that.
So you didn't make a condition adjustment on any of the comps for
I don't
your,
know how to do that. I don't have your software program, unfortunately.
That's
I'm
a
just
very good
making.
judgment.
Okay. Well, it's Realtor for 20 years, I guess.
So you would know,
Potentially, if I had been in the house, yeah.
so you would know what it would potentially be a cost to cure if one home had an updated kitchen, and if you believe your home did not have an updated kitchen, approximately how much it would cost to get the subject to look like the
But
comp.
you told me that it has nothing to do with the replacement, the amount that it costs. You're only giving a percentage anyway.
I believe what I stated was that we would make a market adjustment on what we could see would be a reflected difference. And I believe I used a pool, building a
Correct.
pool as an example. You're gonna spend a lot more to build a pool than you would see a pool being reflected in the sale. You may spend $100,000 to build a pool, but if you have a home with a pool and without a pool, you're not gonna see $100,000 difference in the market.
Mhm.
And I think that's where I was
I
stating was
understand.
that.
But why
that's-
were you just asking me about the kitchen then? That's why
I'm just saying,
confused.
you would, being a real estate agent, you could estimate what a condition adjustment would be between the two comparables to estimate.
It's really hard to know. I'm not an appraiser.
Mhm.
I work with buyers and sellers. And when I show a buyer, I know whether they want a house that's been remodeled or they don't, and what they're willing to pay and what they're not. So I can't say that I did the best I could on these appraisals, being a non-appraiser.
So you would, by that statement then, you wouldn't know whether or not the awful smell of the pet odor would have deterred a
No.
potential buyer.
That is not what I said. I am talking about an updated kitchen, not an odor or,
But I'm just saying,
no, that's
you
not what I
don't
said.
know what a potential buyer would consider when they're looking for a property and what they're willing to pay. You don't know whether or not.
I know if I
If-
show them comps and they think that it's not as good of a condition based on an odor or something like that, they're always gonna offer less.
But you don't, for the subject property, you made the assumption that somebody would not be interested in the property based on the smell or based on the repairs to the wall and paint that was needed. And therefore suggested to the seller that it not be placed on the open market and that you purchase.
I did not suggest anything like that. We discussed, would you be open to me purchasing the home? He did not come back with, I would like to put it on the MLS and you can certainly be one of those buyers. So no, I did not say that. I just said, would you be open to me purchasing?
and then I'll just, finish my part after this. I just can't help but to point these out, is that on all of these comps here, there are plenty of comps on here. For example, there's, so subject square footage is 1492. We have a comp that is 2224, which has a large adjustment. We would typically stay away from a comp that was that
That if you wanted to take that one away, that's fine.
right. But I mean, what I'm seeing here is a lot of adjustments here that are not, that I would say we wouldn't make. And when I look at your sales price on a lot of the comps on here, you have 810, 835, 799, 765, 799, 799, 800, This one's lower, 742. It's also older, 8 months older. But then you have 895, 825, 759, which that one's about 7 months older. So really, pretty much around here, this is pretty close to our 800,000. But with that, there's just very large adjustments on here. That brings it down to the 600s, 500s that I just find it as, for lack of better words, I just find it that it's not an appraisal that warrants these adjustments. Nor does it include comps that would typically be used on an appraisal.
And I disagree with that, and I think that the homes that I've used are very good comps, and I agree that I put 15,000 for an extra bedroom that now I'm learning you don't. I also did not account for larger square footage of lots like 8603 for Firebird that was on the market for 2 months. So I think
Yeah,
we
but
just can agree to disagree.
But I mean, I'm not even so much arguing the comps, it's just more the adjustments and the things that are bringing that value down to your sales price.
Okay, I disagree. I appreciate you saying that.
And that's all.
Okay, I have a question. Can you tell me on your square footage adjustment? What's your methodology behind it?
The only thing I did was base it on the original appraisal. This was the only information that I could use as to why something. So on this one, comp number 1, 1391 square feet was given $18,000. My house is 100 square feet bigger than that, and it was given $18,000. So that's why I'm totally lost as to why 100 square feet would be worth 0. Or 300 square feet would be 0. For 1824 square feet, they gave $59,000. It's a large adjustment. So as a non-appraiser, I don't know how to do it, so I just based it on what information I had there. And I don't understand how, if these are the 2 houses that sold that were not on the MLS, why wouldn't we just take one that also sold that was the same square footage and call it a day? Like, I don't know why we had to go through this whole exercise. That's just.
Okay, I have no further questions. Okay, have closing by the applicant, because the assessor has the burden and they'll close last.
So in conclusion, I've gone over the details and shown lots of, photos and appraisals. I still believe that my home is worth the purchase price that I purchased it for, with the cost to cure, especially not using miscellaneous improvements, not using square footage on lots of other ones. I believe I presented enough evidence to show that it was a fair market value.
Okay. Closing from the assessor.
Just want to reiterate, this was not a Rule 2 open market transfer. It didn't have the opportunity to be listed to determine what a true fair market value would be. Therefore, we have to use the comparable sales. Based on our evaluation, we have an October 2021 transfer. We have an August, a September, and a December transfer. This is a very close time to reflect what was happening in the market at that time. All these homes were built within, a very small, range of, 5 to 10 years different. So the effective year is similar. The quality class is similar. The square footage are very similar, except for comparable 2. They're all single stories. There's very little differences with regards to other, size differences such as garage, except for on comp 2, which we're making an adjustment for. The lot sizes are very comparable, with the usable area on, all of the comps would be comparable to even what the applicant is indicating to be her usable area. We're making an adjustment for the one property on Quail Ridge being superior. So we're, adjusting for that. The fact that the purchase price was $696 in a non-open market transfer and it being 13% lower than the lowest indicated value. I do feel that there is market evidence that supports that is not fair market value. That value was determined because of the relationship between the previous owner and the applicant, and not what a fair market value would have been indicating. And I believe we have provided the evidence that a true fair market value of the subject property as being indicated, even though the applicant indicated the property was in good condition on the preliminary change of ownership report, we estimated it to be an average, appraised it accordingly, and still believe that $696 is not fair market, and that the market evidence supports at $800,000 Prop 13 value, which again is lower than what was originally enrolled due to the error in the first appraisal. And time adjustments aren't needing to be applied because they're all within the very small time frame into which all of these properties would have been listed. Opportunity for market participants to put in offers, to go into escrow, and therefore, using, even though the applicant had provided comparables that sold earlier in 2021, time adjustments do need to be added to those because it's a different time in the market. So we feel that our evidence does support 800 is an estimated fair market value of the property, and request that be enrolled as of the October 2021 date of transfer.
Very good. Okay. I will take testimony and the evidence submitted. I will deliberate after the other cases are heard today, and Brendan will let you know of my decision.
Okay. Thank you very much.
Mr. Russell, I do have one quick question. You had also requested a market value appeal as of January 1st, 2022. Are you still pursuing that secondary matter?
Can I answer that after I find out the
Okay.
results of
So
today?
if we want, we can set that hearing for October 23rd, and if you decide not to pursue it, you can just let us know.
That would be
Okay,
great.
So that would be for Prop 8,
correct. As of just about 2 months later.
22, 10, 20.
Thank you.
Thank you.
Hearing up a little, so it's 12:20, and we have 4 cases left, each about 45 minutes. Did you want to do lunch break now, or try to get one more case in before lunch and do 3 after lunch?
Oh, goodness, this is always such a hard decision. Now, you've been waiting so long.
Is anyone interested in rescheduling at this point? Just a time check. The next case is Mr. Nalon, which will either be now or approximately 1 p.m. Then Mr. Glasgow, whether that's before or after lunch, it'll probably be about 1:45. And then the Lehman case will be about 2:30, and then Hansen case about 3:15. Just given that information, does anybody want to request a reschedule, or is everybody okay waiting for those times? I'm okay waiting. Mr. Lennon, are you okay waiting as well? Yeah. Okay. We do have Mr. Hansen raising his hand. I can go allow him to check in. Mr. Hansen, go ahead.
This afternoon is fine for me as well, or I did send in that the waiver that you talked about if for some reason we want to reschedule it. Either one is okay.
I'll look to the assessor. Any objections?
No objections. I did speak to our appraiser, and she's only available until 4 o'clock. So if we were going to hear it today, and if it went past that time, might run into some
Yeah,
issues.
yeah, okay.
But we're
Mr.
fine.
Mr. Hanson, you do have additional information to give to the assessor's office, is that correct?
I have additional information that I would like to discuss about the case, yes.
And I know at the last meeting, we were having difficulty looking at where the airplane was hangared, where it was based out of. Do you have further documentation as to that issue to show to the assessor's office?
But I've already given the assessor the address, the location of the hangar, power bills from the hangar. And I've already given the assessor the information that shows where it's habitually stored. I'm not sure what else I can provide.
Okay, you didn't have a copy of the lease to provide to them, correct?
I don't believe they asked for a copy of a lease, but I mean, I can certainly, I mean, we own the building. It's not a, you know, it's not a, you know, it's not like we're leasing a building from an airport or something, that we own the hangar.
So it's my understanding we haven't received any new information since.
No news.
Since.
No, no new information has been provided to date.
Okay, okay. Brendan, we have received the 2-year waiver?
Yes, I have received the 2-year waiver from Mr. Hanson. Everything looks okay with that. Let me open that up again. I just briefly glanced at it. Yeah, he's indefinitely extended the 2 years. I do have a question, Mr. Hanson. So you marked that you're an agent of N92714 LLC. Are you a corporate officer of that company or just
I'm a member of the LLC.
Okay, you're a member. Okay. The agent requires you to have special tax agent authorization paperwork signed. So I just want to clarify, you're actually a member of the LLC.
I just didn't see an option for that, so I thought agent was as close as I could get with what was there.
Okay, so would you consider yourself a corporate officer or designated employee of the LLC?
Yes.
Okay, then no additional paperwork would be required. So yes, the waiver would be sufficient as submitted, hearing officer Little. Again, this is a 2021 case, so it is one of our older ones. But if you believe, so the BOE rules do require that significant good cause be demonstrated in order for you to approve the continuance of a case this old. But if you believe that has been met, you can reschedule this case if so desire.
Well, knowing the fact that Mr. Hanson said he does have issues that he would like to discuss with the assessor's office and perhaps some more documentation to provide to them, I will vacate my denial due to lack of appearance and authorize a continuance to October 23rd, 2023. In hopes that this case can get resolved.
Mr. Hanson, are you available October 23rd for a new hearing?
That is my wife's birthday, but I assume I can probably take it if that's the only date available.
That is for this calendar year, unless you switch to the more formal 3-member panel, but as this case has already started, that isn't advisable. So it would be October 23rd.
Okay, let's schedule it for October 23rd. That'll be hard for me to forget.
Is the assessor agreeable?
Yeah, yes, yes.
Okay. Do we need a data proviso?
Yeah, but the data that he's mentioning, then I would say.
Okay.
The proviso.
Within 30 days from today's date?
Is that something that? Yeah.
So Mr. Hanson, if we could clarify, the hearing officer had continued it so that more accurate logs could be prepared. And I don't think that's what you're saying. You're going to, if you were to proceed, you're not presenting that, you're just presenting oral testimony. Is that correct? Or if we go to October, can you provide the documents the hearing officer is requesting?
I told Araceli that I was attempting to get flight logs for that time period. So I am continuing to work on that. And as well, I have both the corporate attorney and the corporate CPAs working on this as well, but I have not been able to get anything back from them. So I will work on getting the further documentation.
Excellent. And 30 days prior to October 23rd hearing, is that adequate for the assessor? 30 days prior,
I think I would prefer 60 days from today.
60
Yeah,
days
that's
from
kind of more
today?
than we need.
Okay.
Yeah.
Okay, to your best of your ability, whatever you can supply to the assessor within 60 days from today's date.
Okay, and just out of curiosity, just so I understand how this whole process works, because this is not obviously something I'm familiar with. I provide more documentation within 60 days, and then the assessor and I discuss it further. And if the assessor decides that they're satisfied with my documentation, then we don't do the hearing, or we do the hearing no matter what, or what's the process going forward?
Yeah, it depends. The main reason for providing the document is the assessor is required to review and be prepared to respond to that. And so they need sufficient time ahead of the hearing to respond. But in some cases, it may result in resolution, or it may not. If you and the assessor do resolve it, then the subsequent hearing would be canceled. But if you do not resolve it, the October 23rd hearing will remain.
Okay, so but there is an opportunity to resolve it between now and then. That was my question.
Yes, absolutely.
Okay.
Okay.
And one other, well, so is this, I think the question was out there, was the next 60 days okay, Mr. Hanson, to provide the assessor with the logs and so forth?
Next 60 days is fine.
I did have I guess not a question, but just a notice. I should have mentioned this last week when we spoke. The hearing officer proceeding, which is what we're in, attorneys are prohibited unless you notify and give the assessor a chance to also consult an attorney. So if you are going to be heavily relying on an attorney, please send a notice to the assessor, and then they will be able to consult an attorney if they deem necessary. Otherwise, attorneys are prohibited in these proceedings. So I just wanted to make sure that was clear.
Meaning in these particular hearings, like if I were to have an attorney present today, that's what you need to know?
Correct. Present or advising on the case, then the assessor also gets the opportunity to consult an attorney, because the law prohibits use of an attorney in appeals with the hearing officer.
Okay, if I end up relying heavily on the corporate attorney for this, then I will let you know.
Okay, appreciate that.
Okay, so ordered.
All right, you're all set, Mr. Hanson.
Okay, have a good day.
All right.
Thank you.
So now we just have 3 cases left for the day.
All right, we're gonna do a lunch break, and let's just do 45 minutes,
1:15 return.
1:15.
All right. Mr. Nalon's raising his, so Mr. Nalon, I'll go ahead and let you talk. So based on this, we're going to start your case right at 1:15 when we return. Is that all right with you, or did you want to request a reschedule?
What time, this is Nalon, what time did you say that I could speak?
1:15, is that okay with you?
How about 1:30?
Well, that will push the other cases. We can put you at 2 if you want to let another case go ahead of you.
I have to leave for a few minutes, but 2 o'clock would be fine.
Okay, so we'll hear Mr. Glasgow first, then Mr. Nalon, and then Mr. Okay, so we'll do you at 2 p.m.
All right, thank you.
Thank you for your patience.
Okay, so lunch until 1:15, and then we'll start back with your case at 1:15.
Very good. So we're not the very last, we're the second to the last after this one.
You'll still be last. Unfortunately, we're required to go in the order the applications are received unless somebody voluntarily goes later. And so your case was received later in the year.
Yes.
All right.
Yes.
I spoke with you.
Yes.
You're so helpful.
On the record.
120. We're discussing agenda item 35, application 22-11506, Christopher Glasgow.
Yes.
Okay. And to the assessor, who has the burden of proof on this?
The applicant has the burden of proof. This was able to, sale where the assessor accepted the purchase price. And therefore the burden switches to the applicant.
All right. That determines who presents first. Go right ahead.
Yes, I've handed out applicants exhibit 1, and I'll just add to that. I think I spoke with Mr. Glasgow about this last week. Because the assessor accepted the purchase price, there's a 5% threshold in order for the hearing officer to issue a reduction. So you have to show that it's worth 5% less than $820,000 in order for the hearing officer to issue a reduction. So applicants exhibit has been submitted.
Okay. Let's go. So, purchased just about a year ago. Mentioned you casually earlier, had my friend, a realtor friend from the west side help me. Figured I'd hire a buddy, which turned out to be not a great idea. Here we are. So found this property for sale, it's listed at 760. Totally in my range. Checked all my boxes with quiet community. As the process went on, the price went up and up and up. I was in a little bit of a situation. I was out of town filming since after the pandemic ended. So Philly for 4 months, straight to Austin for 3 months, home for 2 weeks, back to Austin for 7 months. Got home and just my girlfriend said we're breaking up and we're not going to live together. So a little bit of hurry up and find a place to live, and had a couple of really great years and saved a bunch of money, and I figured I might as well buy something rather than pay some other guy's mortgage. So first time owner, learning a lot as I go here, as I've mentioned. And got a surprise letter that I owed a whole bunch more money in taxes based on the sale price. No one really told me that was going to be something coming. Okay, so I guess based on my conversations with Audrey and the other.
Is it Roman?
What's that?
Roman?
Roman, yeah. Spoke with Roman first. Basically said, hey, I feel like I grossly overpaid. I feel like my estimate was also a little bit higher than 1,300 square foot, 1985 condo in, a nice place, but not, what I thought it was worth. Again, the price of 760 initially attracted me. And I looked around the whole area and it was kind of the best thing going at the time and under a lot of pressure. So just let me touch on some of the things that I spoke with Roman about initially, and then Audrey and I have discussed also. So remodeled unit, in good condition. It's a nice place, move-in ready. Some of the things I found out after moving in, which I think is in the pile you guys have, is day one. Oh no, that's climate control. I'm so sorry. So I'll give you Kerry Gold Plumbing. So day one, moved in to my completely remodeled condo with an unfinished garage, which was just drywall and texture. So decided I should have that painted because I like to have nice things. It was kind of a disaster. So had that repainted immediately, or painted, I should say, for the first time since 1985, which was never painted. And my water heater blew up and died. So there's one of my reasons of saying remodeled like paint and looks pretty is one thing, but plumbing and heaters and water tanks and air conditioning units, I feel like should be included in a completely remodeled place, not just, looks cute, pictures look great on Zillow, we all know how that goes. The pictures always look better than when you get in there. So that was my first expense, which was amazing. Then I did a HVAC checkup before winter came. Growing up in the Midwest, so I was taught to do by my folks. Found out that my heating unit is about to die and is at the last year or two of its life. And that all the venting and piping that leads to the upstairs and whatever else is all the wrong size. The unit's too small for the space with vaulted ceilings. So there's something in your file from SoCal Climate Control that shows price to replace my heater, which is coming very soon. Again, touching on the completely remodeled situation. There's also, next thing is the air conditioner. I took a photo, it didn't come out great, but the serial number I wrote in pen at the bottom, which you can't really read. I do have a photo on my phone if you'd like to see proof of the actual serial number. Basically, that thing is on its 15th year of existence, so that's going to be another cost. Unfortunately, I didn't have the HVAC guy go look at that when he was there. He just looked at the interior. So serial number 07 are the first two numbers, which means it's 2007. That thing's about history, especially living in that climate. It gets used a lot, as does the heater in the winter months. So that touches on, I guess, remodel. I mean, it's like I said, nice place. There's engineered hardwood floors. It's an 80s condo. It's nothing like, no one gutted it and like totally redid it. Bathrooms are okay. Someone had remodeled them, a previous owner, not the guy I bought it from. I was hoping to try to see when permits were pulled on that, to see when the remodel done. But there, you can look at, if you've looked at the photos on Zillow, which I know Audrey did, it's, it's remodeled, it's outdated. Not like 80s outdated, but not, not some of the comps I saw with like brand new tile bathrooms, steam showers, big sit down tubs. Some people went all out, especially some of the upper levels of the community. It's kind of like it was an old quarry. So you go in, you go up a hill. I'm at like mid mountain, and it goes up again, and there's gorgeous, beautiful views at the top, and you can see the mountains and stuff. I did include some photos. Again, when I spoke with Roman, he's like, well, you have an end unit and you have a great view. There's a photo of my view, which is a brown hillside, which burned to 20 feet of the property in 2021. I don't know if you consider that a view. There's also a photo in there of the leaking water heater, which my friend and realtor should have said we want that replaced, especially for the price. There's a photo of the unpainted garage. There's a photo of, there's the guy standing there who painted it. After I had the garage painted. Photo of air conditioning unit. There's another photo of my beautiful view, which looks out the window to, that happens to be my vehicle. Not the gorgeous views you have up top, which I know changes the price, like listening to the case, a couple of cases before mine. Again, also a huge fire hazard, which I have to carry extra insurance for, which is another great surprise. So then we go, there's a bunch of Zillow photos I put in here. My property sold for $820, original asking was $760. Got cut off. Another, and these are kind of current. May 9th, 23, 770, 3-bedroom, 1,300 square foot. Not an end unit, but same size as mine. Another 122 vehicle units sold for 757. Last sold 780 for 656 units. Last sold 500,000 was 122 units on October 24th. I don't know what that was. A family transaction or someone got the best deal in their life. So yeah, I just included a bunch of stuff, estimates and what sold for May 24th, 22, 755, 1055 Eclipse, which was the unit that I first was attracted to this community for. Which, a little more light, but pretty much they're all the same. It's just cookie cutter condos. Next page is 795 Eclipse, sold for 769 on March 2nd of 23. And then I have a February 21 of 23 sold for 760, same square footage, different patio stuff. The higher number stuff is at the top of the hill with nicer views. The up to, I think it's 800 start with the nicer views at the top, where you can see the valley and the mountains across the way. So that kind of touches on some of the things that I was told of why my place is worth 820. My views, updated, and you know these are current comps. Obviously, I was trying to print out comps from before I bought. I mean, basically, I bought right when interest rates were about to skyrocket. People were panicking. I was one of them. On top of moving out with my girlfriend after we gone for so long, and I panicked and I grossly overpaid. Now I feel like I'm just being taxed based on sale price, which, you know, if that's what you guys decide, I live with.
I'm gonna interrupt you for a second. What was your close of escrow date?
June 9th,
Oh, yeah.
2022.
June 9th, 2022?
Yeah.
Okay.
Yeah, so if you look at, I mean, basically, I mean, they got listed at 760 and it went for 820. So either his realtor, I mean, he's probably very happy, and I'm kind of famous in the community. I'm the guy who paid way too much money. I even had some realtors walking around a couple months ago and knocked on the door like, "Hey, we're selling a unit for 760 just around the way. That's a lot of money." I said, "Yeah, I just bought, and that's not a lot of money." And they're like, "Oh, we heard about it." I'm like, so all the local realtors have heard that I grossly overpaid, which was, you know, my choice. Again, no one made me do it. So yeah, so listed for 760 and sold for 820. So that guy made a great deal of money off of it. Let's see. Yeah, let's see, square footage. We talked about, I showed you comps. I mean, it basically went from here's the price of 760s, which was pretty high, to me at 820, and then now it's back up. Even if I wanted, I thought about selling. I'm like, maybe I should just get out of here, but I'd lose way too much money to do that. I feel like fair market value is probably 760, maybe 770, based on, you know, cookie cutter, 1,300 square foot. I think there's a 1,400 square foot floor plan also, which is basically a 10 by 10 room when it comes down to what you're actually getting for that. So, I also included a letter. I've been getting a lot of letters from realtors and people. This is from, I'm guessing, a realtor. Maybe she actually has someone that's looking to buy my house. She's looking for up to 680. That just gives you an idea of what it's kind of going for now and what people are going for, and especially the guys who knew all about me. They're all excited about a house going for sale for 760 and how much money that would be in that community that I live in. Let's see what else did I include here. Just some, like, I think I got some paperwork that shows, you know, purchase price 760, and then, you know, because of what was going on in the market, it went up and up and up. And I had the money to do it, I needed a place to live, and I didn't want to rent anymore. What else I really have to say? I mean, that's basically, I think, all of it. I mean, I grossly overpaid. Now I'm being taxed on grossly overpaying for a place that's worth a whole lot less money, you know, a month or two after I bought it. So,
Okay,
and I mean, it's my understanding also that you're taxed on the sale price. And sitting here listening, I've learned that that's not necessarily true. You're taxed on what the county feels like it's worth. Like that realtor lady who bought for way less, and you guys are saying it's worth way more, or tax you on the way more amount. So I'm a little confused of how it all works. To me, it was explained, you're taxed on sale price, that's it. I learned about the fact that I can appeal and say it's not worth what I paid. And then I learned today that you can be taxed on whatever the county feels like it's worth.
no, I'll let the assessor answer that, but, no, it's
Yeah.
not whatever they decided.
Right.
Market.
Oh, sure, fair
Yeah.
market value, right.
Yeah,
Even if you get a screaming deal, you still get taxed on that. fair
right.
market
So the
value.
difference between this case and that case is rule 2. So your case being listed on the open market. Fair market value supports your sales price, and that's why we enrolled that. When sales price is not fair market value, we still enroll fair market value. It just so happens to be in this case, sales price is fair market value, and that's typically what we do. Typically, when it's listed on the open market, comps were considered, and it usually falls. The majority of them are, but not always.
I mean, I think the highest anyone has paid aside from me was 805 since 1985. So I mean, look, that's my case. I mean, I just paid too much money and I'm paying more taxes. I get it, you can't avoid taxes. But I thought I'd give it a shot and see if anyone thought I deserved a little bit of a break.
I want to just clear one more thing on the rule 2. We mentioned you have the 5% threshold for reduction because they've deemed it rule 2. The same rule applies to the assessor. They can't go above your sales price unless it's 5% more as well. So that same rule applies to the assessor in your case because of it meeting the requirements of that. Okay, so I just wanted to make sure that was clear.
Sure. And Audrey also explained, I mean, she was so helpful in many phone calls. She spent a lot of time talking to me and explaining the whole process to me. And I said, maybe I should just not come. She said, you should come and just put your case and see what happens. And, again, I mentioned you guys earlier, filmmaker with the writer's strike happening, so I've got plenty of time. Sit here and wait for the film work to start.
Okay, are there any questions from the assessor to the applicant?
Yeah, I do have a couple of questions. So during that period of 2022, there were a lot of bidding wars and applicants or potential buyers were bidding higher to get. So it was pretty standard. And I was working in our residential section during that time where a lot of sales, the buyer had paid a lot more than what it had originally been listed for. So were you aware of that? Was this the result of the bidding war? Was this the result of, because you also mentioned that your friend was the agent that represented you.
Yeah.
But what was the actual listing price and how did it end up being the price that you paid?
I found it, I called him, I said, hey, I'm moving way out from the west side, man, I can't afford the west side. I looked at some west sides. Yeah. It was like 900 and those went to like 1.2. Out of my comfort zone. So yeah, I think there were some other interested parties in the property for sure. I mean, obviously that's what drove the price up.
Okay, so you were willing to pay more to get the property.
Yeah, I mean, I was in a spot, so I had to either pay $4,300 to a landlord for a year, or pay $4,500 in mortgage and
Yeah.
own my own place. And I had a couple of great years. You know, after the pandemic, the film business went kind of insane, and it was like, you know, usually you got at least 2 weeks, maybe a month between projects. It was like fly from one to the next one. We've been saving for a house for many years, and I was like, all right, I got enough.
So I imagine when you looked into the property that you were probably aware of what the comps were, like in support of the listing price, but then when you purchased it, you were also aware that those comps were still the same
As far
price.
as-
As far
Oh,
as.
like everything else was going for the 760.
Yeah.
790.
Right.
Yeah, I mean, but that community, that was the, I mean, those places go on the market and they sell in like car days.
Yeah.
And I looked at a handful and they were just gone. I'm like, I can't lose another one, or I'm just gonna be a renter again. And that doesn't make sense financially for me.
At any point in the process, was your agent, did he mention that this was a prime location in the corner with views? Was
There's
that
no
something
views.
that you were?
No,
Yeah, no, I know you
I
mentioned.
Yeah,
No, I know that you mentioned that there wasn't, but was that like? told
No,
you,
I
like-
found the place.
Okay.
And I called my friend. I said, look, I'm buying something. Do you wanna be my guy? I said, I got a couple like Redfin guys that have been showing me stuff that I said, I've been for 20 years and might as well give you the business. And it turned out. I mean, he's looking at, oh, there's stuff right here on the wall. Like, Jeff, what about the plumbing and the HVAC? And those are the things that are important. Or like the giant dog door that's in my sliding glass door. I said, let's get that removed. I don't have a dog. I can't have a dog. I travel too much for that job. He goes, no, this guy's never gonna replace the glass in the dog. You just gotta live with it. I'm like, it's a giant like security dog door. I'm like, I just gotta look at that. He's like, yeah. I'm like, well, maybe we can get him to knock something down. And there was a bunch of stuff wrong with the place. This guy was like handyman extraordinaire. It's like, you know, again, photos look amazing, but when you look at the photo of the fireplace with new tile on it, and the inspector's like, you could only burn gas here because there's no tile on the floor. Because you could, you know, they're designed, they got converted from wood to gas. Because that's not the code. I go, well, I don't need to burn wood, I'll just use gas. And then the gas fireplace was all janky and the insert. And I was like, well, I'll just put a new insert in someday. Well, then I come to find out he tiled in the insert. So in order to put in a new, more modern looking or better functioning, you know, the doors in the metal part, I gotta smash the whole thing out and start all over. And I found a lot of that stuff. That's part of when you buy a house. You get the handyman guy that wants to do it all himself. And I don't know if he did permits for any of the work he did or who did the work. I think the owner before him did the, you know, updating remodel. I don't know what, I don't know if there was hardwood there when the place was built, or if they built it in carpet, or that's considered an upgrade.
You know, I'm good.
Yeah.
Okay, couple questions. I'm looking at your counter offer sheet here.
Yeah.
And I'm seeing under item 1C, item 2, purchase price to be $820,000. Then the next page. Under item 1C. Appraisal contingency to apply. Buyer to accept appraisal deficiency up to 20,000 below final purchase price. So at some time when you were getting your financing on this, the appraisal didn't come in at 820, is that correct?
No, 805,
Came in
which
at
I felt
805?
was high. I felt like 760 was like the perfect price for this place. That's what I thought it was.
And that was a bank appraisal, right? For your loan?
Yes.
Yeah, I guess, I don't know, whoever, I don't
Okay.
know, I know nothing about buying a house, that's why I'm sitting there.
All right, and then.
Yeah, I had to pay some out of pocket. Well, no, I didn't.
All right, and then, when you were talking about, the hot water heater, you replaced that. And then the HVAC, you did replace?
No, but that's coming, and that's an estimate, when I had the winter time inspection done, he's like, this is
Okay, just
history.
see what the status was.
And then the same thing with it.
Okay.
There's also a plumbing leak out of both bathtubs, which I called my buddy and said, I hear dripping in the powder room. I said, we need to do something about this. He's like, what do you want me to do? I said, I just bought it. I had, my first guest came, my nephew, and I'm sitting downstairs and I just hear drip, 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 drip. I'm like, well, we gotta call the seller. He's like, there's nothing we can do. And I'm like, well, wait a minute, like, someone missed a leak because all I've done is move furniture and now I have 2 leaking upstairs bathrooms, so I'm
Okay,
gonna
and
deal with that too, the
Okay.
joys of homeownership, I guess.
a question regarding that. You actually led into my next question. Before you made your offer, did you receive from the seller, what's called a transfer disclosure statement? It's another one of these forms.
Yeah.
And they check off, the house has this, that, and the other thing. And it states, are there any problems? with
Yes,
it?
that was not
Uh,
listed. There was no
There was
problems.
no
listed.
problems listed. Okay, as far as repairs for the seller.
That's kind of why I called my realtor Jeff and said, hey, you didn't disclose there was a plumbing issue. There was a leaking faucet that we had on our list of things to fix, like the fireplace, the chimney cap. Faucet, some holes through the firewall in the garage and into the house. The inspector said that's not safe, it's just sealed. I was like, I feel like we've got a case against this guy. He's like, there's nothing I can do to help. Call it.
Okay, well, that's the reason in real estate for that. The transfer disclosure statement is actually in some cases more important to a buyer than your purchase contract.
Yeah.
Because that is a legal document from the seller to the buyer to disclose anything that's wrong with the house. So that's a very important document for you.
I have that in my files.
Okay, and then that leads me to the other question. It sounds like you did have a physical inspection with a contractor during escrow.
Yes.
Okay, and did he mark that there was water under the water heater or?
He said to ask about it.
Okay, it was
And-
in his report.
Yeah, and that's one of the things I was trying to print this morning. That I think Audrey had said to you, you have like everything under the sun. I sent you a million things.
Okay, so there were some things on that report.
Yeah, and I asked my good buddy, he's like, "Dude, just buy it, man, or the guy's gonna pick the other buyer." He's like, you don't have a leg to stand on it. So,
Okay.
I mean, he kind of explained to me, like, we bought a house near the airport in Westchester, we did all kinds of work to it. I was like, yeah, but you paid $550. You knew you were buying a fixer upper. I'm buying a move-in ready, but there's some things that are not right.
Okay. Great. Those are all my questions.
Okay.
Okay, and now the assessor.
Maybe you have your stuff.
I didn't print all that, just you're gonna have photos and stuff. So this is based your appeal for a change of ownership that occurred on June 9th, 2022. It's a tract condo in Westlake. It was purchased for $820. The purchase price was accepted at fair market value and enrolled pursuant to Revenue and Taxation Code, Section 7510A and 110.1B. That code basically says the purchase price of the property is presumed to be fair market value if sold on the open market. And this was a open market transaction. The property was listed and transferred at arm's length between unrelated parties represented by brokers. The presumption of that rule would be reviewed by evidence that the full cash value of the property is significantly more or less than the total cash equivalent of consideration paid for the property, A significant deviation means a deviation of 5% of the total consideration. Based on the assessor's appraisal of the subject, it indicated that the purchase price of $820 did fall outside of the adjusted value range of the comparables that were used, but was within the 5% allowable deviation under Rule 2, and therefore was considered fair market value. Our appraisal, which is on page 7, it included 3 comparables within the same tract, including 2 model matches. The subject had some recent updates and is considered to be in a superior average condition. All of the comparables were considered to be in similar updated condition. Comp number 3 is adjusted downwards for being a slightly larger unit, larger living area. The sales date of the comparables do encompass the sales date of the subject, to include directly before and directly after the 6/9/22 sales date. In our conclusion, the assessor's appraisal indicates that the subject purchase price of $820 was fair market value under the property tax rule 2 as of the 6/9/22 purchase date, and therefore requests that the appeal board sustain the base year value that was enrolled as of that change of ownership. On page 3, it shows the listing description of the subject property, and 4 through 6 are some of the photos of what was updated.
Yeah, but you know, I can't interrupt you. What was updated? Like, when was the last time you were in there, and when was the last permit pulled that they?
Okay, you will have a chance to ask some questions after they make their presentation.
So this is just the, as of the listing, what the subject property looked like. Again, on page 7 is our appraisal. You can see that comps 1 and 2 are both model matches when sold prior to the subject and when sold just after the subject. And then the comp number 3 is just that slightly larger unit. And the adjusted value range, or the top of the value range was 782, but the 820 does fall within the 5% allowable. And then pages 8 through 16 are going to show the listing photos and the listing description of the 3 comparables that we used. You can see that, you know, they may not have been all completely remodeled, but they're, you know, shows some updates, you know, some comparable to the updating that was done in the subject property. I believe only one of them may have been an N unit. Maybe not. Maybe not all of them, but you can see, you know, recent updates, but I wouldn't say necessarily a 100% just flipped type situation. And then on page 17, it shows the just a map of the subject property and where the comparables lie within that same community there. And that concludes our presentation.
Okay. Now, any questions regarding the presentation?
Just to throw out there, the comps of 1000s, those are all up top of views. I mean, this is, for lack of, this is kind of what you look at when you're at the top of the community.
Mm-hmm.
I look at ground, you did? Mm-hmm. Yeah, it's a populous community. Yeah, I look at ground bill.
So like comp 2 and 3?
Yeah. And those, when I was looking, those were higher price. It basically starts at T.O. Boulevard, and as you go up, it gets better. And the ones up top, the day they go on the market, they're gone.
So your question is, do you see
We didn't have we didn't have listed or indicated on the comparables that they were indicated to have a view. Therefore, we didn't make a market adjustment for them. We would have to go out to each property to evaluate, because sometimes view ratings are established when a community is built, but maybe things get built around it that then obscure.
It was built in
so-
all, like at once, 85, 86, and
Yeah.
built from the ground and started working their way up.
So sometimes when they were built, we established a view rating, and then sometimes things
I mean,
change.
they're all nice. I mean, up top's more desirable. You get that nice breeze that comes over the mountains. A little more light and a gorgeous view.
Yeah, so we didn't have anything indicated that they
Sure.
had a view. We, depending on the listing photos, and then potentially there could have been, but without going out there and doing an evaluation. So we didn't make an adjustment for those. To address the updated question with regards to the subject, we can say that it's updated from when it was built. So we know, the flooring is not the original flooring, the cabinets aren't the original cabinets.
Oh, I wouldn't say that. They're clearly the original cabin.
Like the front boards, or like
The-
the structure area itself.
Someone painted them white and put knobs on them. I'm sure they were like the 80s style with no knobs that you just pulled open. Maybe they put glass. I have one that's got some glass on it. I mean, it's look like you walk in, you're like, oh, this is great. And you start looking at it, you're like, these are just old cabinets. They did put new cabinets in the upstairs guest house, which is actually worse because there's a nice big countertop the way it originally was. But yeah, like I said, it's not a bad place. I'm happy to live there. It's just not like someone gutted it and like put in Viking appliances and steam showers and walk-in bathtubs. And, all that. And no, there's no view. I mean, I'm just basic. Like I said, I started with things that Roman said. He's like, oh, you got end unit and a view. I'm like, I don't have it. And I have an end unit that burned right up to the edge of the building a year ago. But not unhappy living there. Just feel like, I mean, I know I overpaid. It's common knowledge. You can ask any realtor in that area. And if you know the area, officer, it's very sorry. It's lovely.
So any further questions on what they presented here?
I mean, the only thing I had to say, I mean, the photos as a professional in the industry, these are like highly adjusted. I mean, obviously, it's real estate photos. They're supposed to make you want to go there and take a look at the place. Like, just looking at the green, like it's never that good. Brown, that whole side, just brown grass. But yeah, like I said, I'm not complaining about the place or where I live or what I did, but I know it's not worth $820,000.
Okay, I'll ask a question. The comps that the applicant has submitted, have you looked through those? Any of those you feel are relevant?
Those are all within the last couple of months.
That's what
I mean, I only have access to
So-
Zillow, Redfin. I don't have the access to all the.
As we have,
Yeah.
as we have spoken, there's a difference between appealing the base year and appealing an annual value. We did say the comparables we can consider based on the date of transfer, may support a Prop 8 value for 2023. So some of them, we can use, but just based on the, 90-day rule past the date of transfer that we can consider, some of these can't be used for a base year.
I think
6
it's
months
6 months
prior.
before and 6 months after.
6 months before, or anytime before, really, and only 90 days after.
Oh, I thought it was 6 on each side. Okay.
But yes, so some of these we can consider for a market-based valuation for the next year, but with regards to, the base year, we have the comparables, like I said, one was right before, one was after, one I think was right around the same time.
Yeah, there's a handful. that's
Yeah,
sort of
just
there.
kind of a picture of what was happening in the market at that time. And like I said, our range does show the purchase price being the high end of it, but within the 5%. There's a range. Somebody's got to be the lowest, somebody's got to be the highest. As you said, you're that guy.
Yeah,
So-
trust me, I'm that guy. I was like, I thought my neighbors gonna love me. I made their place with more money. I'm like, nope. I just, they were back to the same price they were before the market was going nuts.
And then the cost to cure on the items, the water heater and the HVAC, there's $2,200, 66.77 on HVAC.
Right.
I didn't get the AC looked
I
at.
know.
That's just a heater.
Oh, that's just.
Yeah, the guy, I
Only-
forgot to
just
ask him to
because
look
I
at the
checked.
air conditioner, which I looked at yesterday and looked up how you read the age. Which strangely, the guy who praised the place was like, there's no way to know the age. I'm like, yeah, there is. You look at the first two numbers of the serial number, it tells you the year it was made. But whatever, you know.
So for
That's
the
his
cost to
method.
cure, again, is something we could address because it wasn't the known issue on or prior to the data transfer. It was something that occurred after the data transfer. So it's something we definitely can consider for a 2023 update for the cost to cure.
I'm happy with anything. Being the base year, getting it down is ideal. If I can go down to Brandon's office and get next year after that knocked down to what's actually the places where I'm happy to do anything.
Yeah, just remember, the base year affects in perpetuity, so long as you own it. Proposition 8 only reduces it until the following year. The assessor puts it in their computer and they basically look at it every single year. So if real estate prices come back up, they will restore your base year value. So it's a temporary reduction.
Okay.
And even if you have it reduced several years, if the market increases dramatically, your taxes can go back up dramatically.
If they go up dramatically, I'll sell it. 830 and walk away from it.
There's double-edged swords everywhere.
Yeah, no, I, so what, I mean, what does that mean though? I mean, this is probably a total sidebar, but just educating me, but if the value goes up to like 805 in, say next year, I get 23, so that'd be this current year taxes, which will happen later in the year, right? Kind of like this when you guys set it up about it. So say the following year, it's like, you guys will say, you send me another letter saying the place is worth X amount of dollars now, based on what's going on in my community,
Yeah,
as
in-
far as sale prices.
In the
go?
market, correct.
But that's when Prop 13 clicks in.
Yes, so we have to do a market evaluation and which is, so basically, as your data transfer, that's a market evaluation. So you establish your base year, your Prop 13 value. We can look at it the subsequent tax year as a temporary reduction for the 1 year based on what's happening in the market at that time, which is something these comparables we can consider. But that's not going to change that starting point. And then every year we would evaluate what's happening in the market. And at any time, your estimated fair market value is higher than your Prop 13 value with whatever inflation factors applied. We either reinstate that Prop 13 value, or if the market value is lower, then you get the market value. But that value
What's
can
the Prop 13, that's my set price at 820, so just. go back
starting
to
point,
820.
you'll be with inflation factor to increase no more than 2% annually. So for 2022, you would have 820, 2023, you would have 820 plus a 2% inflation factor. 2024, if,
You never go up over 2%.
yeah, so you would just basically add 2% every year from that point on. But to counteract that if the market values decrease, we can only tax you on either fair market value or your Prop 13 factored value. So that's where we do the two different evaluations. Is there any other questions?
I have a question for you, and this is not have anything to do with the decision, but I was looking at tax history of this property.
So that might be based off of any
It's nothing to
previous
do with you.
over, yeah.
No, I know, but it's just a question, just so I can learn if you guys don't mind. like, helping me learn more. So it shows 22, 6,000, up 1.9%. So 2017, and this is Zillow, I don't know what that means, but
Oh, yes.
it went up 126.1%.
It may have been a change of ownership at that time,
Okay.
but I don't know. That sounds kind of. a
Yeah,
really high
oh, I
value.
see, because it was 2,539, someone, oh, that's when the guy I bought it from bought it.
So there might have been a
So
change.
then and it went from 253 to 574 for him. And then it went up 2%, 2.4, 2.7, 7.2, 1.9. Okay, I just saw that number, I was like, how did it go up? 126% sale. Okay, got it.
Okay,
All right.
closing from the assessor.
Yes. Again, this is a Rule 2 open market transfer where our evaluation, shows that the 820 is fair market value based on other comparable sales in the 5% allowable deviation under the Rule 2 guidelines. The value was, again, accepted as fair market value and enrolled as of that date of transfer. And we request that that value be sustained for Prop 13 base year as of that date.
Closing by the applicant.
Please take it low. I got nothing.
All right, I will take the evidence submitted and the testimony submitted, and I will review the cases after I hear the other cases today, and Brendan will notify you after my decision.
Okay, great. Thank you so much for your time.
Thank you.
And then what do I do? And that'll be like later today, tomorrow? Then I go to you and I say, I wanna
I'll
file all this stuff with you to try to
So-
get it lower for.
For 2023, you can file, anytime now. I can, if you don't remember your password, I can go ahead and send you a password reset email.
Oh, I could just do it online?
Yeah, you just
Oh.
log in and hit, it's real easy. There's a button that says copy last year's appeal, and then you submit for this year, and you're all set. You will need to make it a market value appeal instead of a base value appeal, but other than that, should be
Which I
very
think is
quick to submit.
what is it, B?
Yeah, you have B2 selected this year. If you look at this, when you file out the e-file.
Yeah.
You'll see this in your account when you log in. And the only change you'll make is it'll be a regular appeal and it'll ask you that, and then you'll be doing a market value decline instead of B2 for the base value.
And then
So
what do
you just
I
submit that.
put a
online.
number or you guys determine the decline? How does that work?
The same process will, as what happened today will.
Oh, then I gotta
You'll have
come
a
do it.
chance to work with someone from the
Oh.
assessor to establish a value.
Okay. All right, cool. All right.
You can also request an informal review with the residential valuation.
What's that?
They
another
basically do,
hearing?
no. They basically do an appraisal informally. They just may not get it done by the September 15th deadline. So in order to preserve your appeal rights, they're gonna say file an appeal, but it may be able to be resolved without the need to go to hearing
Okay.
if they do the market evaluation and determine a reduction is warranted. Yeah, informal review, residential valuation.
All right. I'll call
Yeah, the main number and
the clerk's office. I'll
put it
just-
in. Yes, Brendan, you can call
I'll just
Brendan.
come see Brendan. Easier to get help from you guys and try to figure out. Thank you so much for your time. Hope your day was quick.
Good luck with everything.
Thank you. Yeah.
Hopefully work
Pray
out.
for the writers
Yeah.
and the actors. And I can do that.
All right,
Yeah.
thank you.
I got it. Have a great day.
Thank
You
you.
too.
All right, we're on to Nalon now.
Neil.
Do you have you have the burden of proof, correct? Because it's owner occupied 1/1/20.
Oh, wait. Oh, he's on mine.
Yes.
That's why I was like, why do I only have two?
Mr. Nalon, can you hear us all right?
I can hear you. Can you hear me?
We can hear and we can see you.
Excellent.
Give me just a moment, and in the Zoom chat, I'm going to send you the assessor's presentation.
Thank you for your patience.
Yeah,
One day.
too much anxiety of not having something to look at. Mhm. The water's the important part.
All right, Mr. Nalon, if you look at the Zoom chat, you should see the materials from the assessor that have been submitted. Let us know when you have that case presentation from the assessor open.
I didn't understand that.
In Zoom chat, you should have received the files with the assessor's presentation. So just let us know when you have that open and are ready to go.
I didn't receive any other than an email from the assessor.
So if you go to the chat for Zoom, at the bottom of your screen, you should see some materials.
Okay. We click on it.
Yes, go ahead and open that and let us know when you have it ready.
Well, I can't get it up. I shouldn't say it that way.
I can go ahead and try to email it to you.
Well, why don't you just tell me what it is?
It's the assessor's presentation.
Okay, so I see a bunch of stuff here, but it says appeal application, hearing presentation.
Here, open the hearing presentation. That's what you want to look at.
Okay, it's got about 20 different files here.
That might be his.
Yeah. You should see.
It's the first time I've ever seen this.
Let's
Playlist
see.
folder.
Yeah, you should see the assessor's presentation, which is 42 pages.
All right, well, why don't you, let's do it this way. I can't seem to be able to open it. Can you just tell me what it is?
Yeah, the assessor is going to present it right now. We just wanted to make sure you had a copy. So you're okay with proceeding without a copy.
Well, I'll have to figure out how to open it up later, but I didn't know, other than her email, I didn't know that you were going to present any evidence, but go ahead.
Okay, I'll email it to you as well. So we'll have Mr. Mears proceed. And so assessor's exhibit A has been submitted and we have a copy of an application. And this is the market value as of January 1st, 2022 for a residential property.
2022?
January 1st, 2022, correct. Is that not your understanding?
That's my understanding.
Okay, the assessor has the burden, correct?
Correct, yes. This is a Prop 8 decline in value appeal for January 1st, 2022 rule year. This is owner occupied single family residence. We have the burden of proof. The subject property is a custom SFR in the North Ranch neighborhood of Westlake, originally purchased on August 26th of 2020 with a stipulated purchase price of $2,649,000 as the original purchase price of $2,740,000 included personal property and buyback rent. So the stipulated base year value was accepted as fair market value and enrolled pursuant to Revenue and Taxation Code Section 75.10A. Pursuant to Revenue and Taxation Code 51A and Property Tax Rule 2B, the assessor is required to enroll the lesser of a property's factored base year value or its full cash value as of the lien date, which is January 1st of each year. As of January 1, 2022, the factored base year value of the subject property is $2,701,980. A Prop 8 market evaluation was conducted and determined that an estimated fair market value of the subject property is $3,016,500. The Prop 8 value of 2,701,980 was enrolled as of January 1st, 2022, as it was the lower of the two values. For the assessor's valuation, which you can see on page 10, it included 3 custom SFRs located in the same North Ranch neighborhood as the subject and are less than 0.5 miles away. Per the 8/26/2020 transfer, the subject was in average condition and was appraised accordingly. The subject has a nice hillside view and all comps are adjusted for lacking a view. All comps are also adjusted for inferior lot sizes compared to the subject. Comps number 1 and 2 are adjusted for superior living area and are considered to be in a similar average condition with some updating done and are well maintained. Comp number 3 is adjusted for inferior living area compared to the subject and is adjusted for a superior updated condition as well. Additional adjustments were made to the 3 comparables where applicable that included for superior bathroom counts, inferior garage sizes, and other miscellaneous exterior improvements. So the assessor's appraisal indicated that the estimated fair market value of the subject property is higher than the 2022 factored base year value, with the lowest value indicator being more than 200,000 higher than that 2,701,980. The assessor therefore requests that the Assessment Appeal Board sustain the enrolled Prop 13 value of 2,701,980 as of the 1/1/22 lien date. On pages 3 through 9, you'll see the 2020 transfer description and the listing photos. See the condition of the property and the view of the property as well. Again, page 10 is the market evaluation of the comparables. And pages 11 through 40 is photos and listing description of all 3 of the comparables used. And page 41 shows the map of the comparables and where they are located to the subject property. And that concludes my presentation.
Okay. Are there any questions from the applicant to the assessor regarding her presentation?
Well, I'll give mine and then we can cross-examine, right?
No.
No, you typically, after they make their presentation, you have the opportunity to ask questions of anything that they presented.
All right, on your presentation, you use 5580 Greyfeather Court at 3,076,000 as a comp to support your position. How do you use that as a comp when the price per square foot is $501 and that was a refurbished home?
Because we don't make adjustments, or we don't take the sales price and divide it by the living area. We make market adjustments based on the differences of the comparable to the subject, and then get an estimated market value of the subject based off of those adjustments. We made an adjustment for it being in superior a living area, for it having superior miscellaneous improvements, which would include decking, patio sizes, barbecues, and such. We did make an adjustment for it having inferior usable lot size and for it lacking a view. So when we adjusted the 3,076,126 sales price, it adjusts down to 2,912,000, which is higher than your Prop 13 value. Therefore, we're obligated to enroll the lower of the 2.
Does it support your position or my position that the value of my house is the stipulated value?
I don't understand the question.
Well, you say you do not go by price per square foot. That's the first time I've ever heard an assessor say that. So how do you compare it to?
Well, we made the adjustments to the differences that the comparable had to the subject. So we made an adjustment downwards to that property for it having superior living area and superior miscellaneous improvements, but it had an inferior lot size and an inferior view. So based off of the total adjustments that we made to the subject's purchase or the comparable's purchase price, we get an estimated value of the subject property being 2.9 million, which is higher than the 2.7 Prop 13 value.
Yeah, but it's also got more square footage than the house.
I'm going to step in here and say to the assessor, the applicant may not have this on his screen yet. So can you give him the adjustment amounts, please?
So we adjusted 5580 Gray Feather Court down $256,000 for it having 6,138 square feet, which is larger than the subject property. So we accounted for the difference in square footage by adjusting the purchase price down 256,000.
Okay, but you're telling me that my property is worth 3.1 million and it's got 4,950 square feet. This says 6,100 square feet and it's 2.9 million. That doesn't make any sense to me.
Well, it was sold for over 3 million. So the 6,000 square foot property is worth over 3 million. But compared to the subject property, it is adjusted downwards to 2.9.
Fine, why isn't this property that I'm in reduced in value to the price per square foot that was paid for this if they're comparable?
Because the subject property is I'm trying to find the word. Your Prop 13 starting point was enrolled, and the property is subject to the inflation factor of 2021 and 2022, which is why the purchase price is not the same for 2022 because of the inflation factor that gets applied to all properties in California.
I understand all that, but let's back up. Is it not true that I overpaid for my property by $100 a square foot, a minimum 50, probably $100 a square foot? It was the highest valued property at the time during the pandemic. And you and I have rehearsed this over and over again. And
We stipulated
a Prop 8.
Yeah, we're discussing a Prop 8
Not a base
value
year.
as of January 1st, 2022. We did stipulate to your purchase price being $2,649,000. So that is your starting point as of August 26, 2020.
I understand that $2,649,000 is still $540 a foot. No, I don't understand why you're saying your document worksheet has a box there that says price per square foot of living area. So it is relevant. The assessor's office sends out what's called a property tax comparison worksheet. We, as the homeowner, are supposed to fill this out with all the boxes checked, which I did. And the last box on the page says price dollar per square foot of living area. And I gave you 6 comparables. And now you're telling me that price per square foot makes no difference. I don't understand that.
I am not saying that it makes no difference. I'm saying we're accounting for that in our appraisal.
All right, fine. So let's go through price per square foot. I've given you 6 properties and just for general discussion purposes, these 6 properties, and as entered in the box on your form, is an average of about $475 a square foot. And these are all the comps that apply to January 1st, 2022. So if that's a box that's available for me to prove my case, the price of this property in January 1st of 2022 is $475 a square foot, which is $2.4 million. Now, I stipulated to $2.640 when you and I first started discussing this, and that's where I think this property value should stay. The property in no shape, I'll wait till you're done talking now. This property in no way is worth $2.7 million, $2.9 million, or $3.1 million. This property is worth less than what I bought it for. That's my argument. And I think this box that's on your form, which pertains to January 1st, 2022, is sufficient proof that this property is well less than what we stipulated to. But for discussion purposes, the reason I'm here is that I'm not about to let this property go up because of inflation when I have a property that was built in 2000, which is depreciating. And I've given to you, as the assessor, a copy of all the repairs of about $200,000 that had to be done to this property, of which probably 150 still are outstanding. So I don't understand why we're here, frankly. Are you have never refuted, in fact, you did agree that my repair prices were reasonable. Whether they're relevant, whether they have any weight, I have never got a response to that. So my question is this: adding up all the comps that you gave, I think that you support my case. I'll stipulate that the property is worth $500 a square foot. That's what you basically cite here. $500 a square foot means my property is worth $2.4 million. So can you tell me where I'm wrong?
I'm not sure which form you're looking at.
Yeah, I can clarify, Mr. Nayland, your case hasn't been submitted into evidence yet, so I think you're referring to your case presentation and the calculations you did. The assessor has not been permitted to see that yet because it's not your turn to present. So once it's your turn to present, they'll have that for reference.
Okay.
Okay, this is the time if you have any questions regarding what the assessor presented to you.
All right, well, I'll ask this. Can you, I don't understand your comps. Can you explain them? On a price per square foot?
We don't strictly do a cost per square foot, and I believe we've had multiple conversations about that. We take the comparable, and where it is different to the subject, we make market adjustments upwards or downwards based on those differences to then generate a estimated market value of that comparable that would reflect the subject property. Based on the three comparables that I used, 5580 Gray Feather Court, 1500 Pathfinder Avenue, and 1630 Windy Mountain Road, all of those all those sales prices have been adjusted downwards to reflect an estimated market value that is higher than the subject's Prop 13 value. Therefore, a reduction isn't warranted for January 1st, 2022, when we make the market differences between the comparables and the subject.
I understand all that. We reviewed that. You still can't explain to me the disparity in the price per square foot, though. I don't understand that. I'm not saying it's the whole issue, but I'm saying it's a great part of the issue because homes are sold on price per square foot.
Homes are sold for the characteristics they exhibit. So
That's not correct. Homes are primarily sold on price per square foot. I'm a real estate broker. I can
we
testify.
can just agree to disagree then, Mr. Nayland.
I can testify as an expert witness that all properties, a main criterion is price per square foot. I know that there's auxiliary situations, but price per square foot is the main impetus behind a price. And you as an appraiser and an assessor should know that, or else it would not be entered into your worksheet. So
And we're accounting for that in our appraisal.
I don't understand how, I don't want to rehash this because I know people, it's been a long day. But I won't ask any more questions. I'll just present my case then.
Okay. All right, I have no further questions. All right, we'll hear the applicant's case.
All right, I bought this property for $2,740,000 in August, the assessor said, as a somewhat of an emergency sale. I know I overpaid for it by $100 a square foot. And the reason I know that is because the property next to me sold for $1,625,000. And it had a lot that was similar. Living area was only 900 square feet less. It had a pool, but I went ahead and bought this property anyway because my wife was sick and I had to have a place to move into. All that to be said, we stipulated that the value of the property, Ms. Ramirez and myself, that we would arrive at a base value of $2,694,000, I think the final figure was. My position today is that the value of this property, despite the application of the Prop 13, reevaluation and all that, has gone down, not gone up. One of the salient facts of which I submitted to Ms. Ramirez was the repairs. When I found out that I had, after I moved into the house, which are almost $200,000, which included a leaky roof. In fact, the roof was so leaky that we were flooded out this winter during the heavy rains. And we had to redo our entire not entire, but half of our first floor. So I have bills to prove that if that is ever requested. Going through my comps, my property tax comparison worksheet, the last box shows price per square foot that ranged from $400 on Indian Trail to $501, which is Ms. Ramirez comparable at $501. So I'm not an appraiser and I'm not an assessor, but I can tell you that if she appraises my property at $560 a square foot, that's $60, $70 higher than the average of all these comps that I produced. And I haven't seen a refutation or any facts contrary that would reflect on the weight of those comparables. So my argument today is that the property value has not increased. If anything, it's decreased. But I think a logical conclusion to my argument would be that I am willing to stipulate that the price should stay the same at $2,649,000. I'm sorry, $2,694,000. Well, I'm sorry, whatever we stipulated to.
I believe it's $2,649,000.
I'm sorry, yes, $2,649,000. That's my case.
And the assessor's opinion of value is $2,701,980.
Recording in progress. Recording stopped.
Did I hit something?
That was my fault. I lost my internet connection.
We okay?
We're all good.
All right. I'm done.
Okay, so I don't know if you heard me or not, but I was looking at the assessor's exhibit A, and it says their recommended value is $2,701,980. And you're proposing $2,649,000. Is that correct?
That's correct.
the stipulated purchase price as of the August 26, 2020 data transfer without an inflation factor applied is what it's requesting. Mr. Nayland, I have a question with regards to your comparable number 1 at 5833 High Cliff. This was an August 2020 date of transfer. Was it an adjustment made for the time difference since we are looking at a January 1st, 2022 date of value? And we know that the values increased from August 2020 to January 1st, 2022?
I'm sorry, are you asking me if the value of property has increased from 20 to 22?
Well, sales prices increased from August 2020 to January 1st, 2022, which we are looking at for an estimated market value under appeal. So I'm asking if a time adjustment was applied to the purchase price of 5833 to reflect that increased value.
I don't think that I have the right, nor you have the right to comment on properties that were outside 90 days from the date of transfer that we're discussing. I throw this in there to give you a comp, and you can decide what the weight of that comp is. I can't. You're the one with the rules, not me. So I threw it in there to show you that I overpaid by close to $150 a square foot. I'm sorry, yeah, close to $100 a square foot. Now, if you want to say that increase in value, okay. What can I say? Could increase to $500 a square foot, still $50, $40 less than the price of my house, which is $200,000, right? So however you adjust it, however, whatever formula you use and what auxiliary applications you use, I would say probably the house went up in value, but still supports my position that the price of my property is no more than $500 a square foot or 2 million, whatever we discussed, 2,649,000. So I'm not sure if that responsive to your question, but that's the best I can do.
So you just stated that it is possible that the value of your property has increased since its purchase date.
I know I could never get what I bought it for, if that's what you're asking me. Not with the repairs that are required. And not with the, we're talking about January 1st of 2022, correct?
Correct.
What would I get on, your question is what do you think I would get on 2022? On January 1st of 2022 if I sold this property?
So that is, yes, that is what we're estimating would be an estimated market value as of January 1st, 2022. And if you stated that on August 20th or August 28th of 2020 to January 1st, 2021, the value of your property increased from your purchase price, would that not be an accurate to see an inflation of that 2,649,000 value to be reflected on January 1st, 2022?
No, because the comps don't bear that out, and the 200 and some odd thousand dollars of repairs dissipates the inflation factor. So there is no inflation factor on this house.
So you mentioned that repairs were needed on the property. You mentioned something about a roof. When was the roof repaired?
It hasn't been repaired, which is why we had the flood.
So what repairs were done since you purchased the property?
I think I gave you the attachment. I can find it here.
It's in his applicant's exhibit, right before the High Cliff comparable. There's 2 pages of repairs. But
Those are
his-
estimates.
Yeah, applicant stated he had $200,000 worth of repairs but $150,000 are still outstanding. Is that correct?
That's correct.
And we spent about $50,000 in repairs,
Yes, I have.
just ballpark. Can you tell us which items have already been taken care of?
Some of the items were taken care of.
Can you give me an example?
We repaired the siding on the house. We installed we took out all the foliage and put in water, water conservation covering. We fixed all the mold on the eaves. Primarily, the only thing we have not done is we've not repaired the siding of the house and the roof. Siding on the house is about 50,000 and the roof is about 100,000. So we're talking about 160, 170,000. I repaired the roof, but I cannot afford to replace it. And I didn't want to replace it in the last year because of the rains. You never knew when a rain was going to hit. So, but we did have a major leak. The first floor.
So the roof was repaired, just not replaced.
Correct.
And when was the roof repaired?
In August of 22.
So after January 1st of 2021, excuse me, after January 1st of 2022, it was unknown as of that date that a repair is needed. Is that correct?
No, we found out that the roof needed a repair after we bought the house, and I'm sorry, after we went into escrow. And a repairman, I'm sorry, what do they call them? Housing inspector wrote a report and said your roof is shot, you need a new roof. And we never got credit for that in escrow because the seller was a little bit difficult to deal with, but we went ahead and bought the property in anticipation of someday repairing the roof, replacing the roof. As a matter of fact, we got a bid on August 1st of 2020, which you have, showing that the roof repair was proposed at $116,000. That was dated August 1st, right when we were in escrow.
Okay, are there any further questions of the assessor's presentation?
I'm
sorry.
Do you have?
The applicant's presentation.
I guess my one question would be, if you take our estimated market value bottom line of the comparables, which I stated was 2,901,000, and deduct the 200,000 that is still needed in repairs, would we not arrive at your Prop 13 taxable value of 2.7?
No, because you're forgetting the essential salient question here is that I overpaid by $100 a foot on the comps in August of 2020. So the base price is too high. You can't.
We
We're
can't
not talking about
we
base
can't
year.
talk about your base year because that was already stipulated and agreed to.
Okay, well, I don't agree. So how do you want me to answer that question? If you won't let me use a fact, then I can't answer the question. You asked me to agree with you. No, I don't agree with you. I will never get $2.9 million for this property. It's out of the question. Not in its current condition and not even price per square foot. It doesn't merit that. This is not a refurbished home. This is a home with the same essential elements as it was when it was purchased. When you talk about homes that are selling at $600, $700 a square foot, you're talking about homes that have been gutted. I know a lot of homes up here have been gutted and they're selling for high prices. This home has basically outdated interiors. So that's why I will never get 2.9 until I gut this place and put $500,000 into it if and ever I want to do it. I'm 75 years old. I'm a disabled veteran. There's no way I can go through that. My wife is 75, she's disabled. So I can't answer your question to the extent that I can speculate that this price is worth 2.7 million, stripping away the 2.9 that you think the property is actually worth. So I hope that responds, but we'll see.
I guess another question with regards to, we'll go back to your comparison worksheet on your comparable one. You have about a 900 square foot difference in living area. So did you make an adjustment for the subject property having more livable area than the comparable one, which would then increase the cost per square foot?
These, are you talking about 5833 High Cliff?
Correct.
Well, the living area is 4,078.
Correct. So did you make an upwards adjustment to that purchase price to reflect the subject property having superior square footage?
Well, how can I do that? Because that would be a reflection of the price per square foot. So I'm at $416 at 5833, and I'm at 540 on 5808. So I don't understand what you mean. If I took the difference in the square footage of 900 square feet, that's $360,000. Right? I don't understand your question.
That's okay.
I think if you approached it that way, you support my position.
I don't have any further
Yeah,
questions.
well, I think the only thing that I want to mention about that is that the dollar per square foot, that's so that it doesn't account for the differences. So I think that's where we're kind of in a position where that's why we don't solely, we're not valuing it based on that. That's more the result of the valuation. So because the same thing for comps 2 and 3, there was not an adjustment either downward or upward for size. So I just wanted to mention that as well.
Oh, can I comment on that?
Sure.
All right, so the sale number 2, Lakeville, sold the day before the day in question here for 437. It was 7,998 square feet, sold at $3.5 million. So how do you not use that as a comparable to show that my property is overvalued by over $100 a square, $140, I'm sorry, $100 a square foot? I don't understand that. I don't see any adjustment necessary. It's 7,998 square feet, sold at $437 a square feet on January 1st of 2022 or thereabouts. And then if you do a side-by-side comparison, 508 High Cliff is worth about $2.2 million. So I think that supports my position, even that using that one variable. Same thing with Indian Trail, same thing with Greyfeather, Pathfinder, et cetera, et cetera. I don't know. I don't know if you've inspected these properties, but I have. So
I think we just have a difference in methodology here, so,
I agree with that.
yeah. Okay, are there any further questions of the applicant's presentation? Okay, we'll have, the assessor has the burden, so we'll have closing remarks by the applicant.
I have nothing to say. I think I've said it, so I'll rest my case.
Thank you, sir. All righty, and closing from the assessor.
Again, the assessor's position is based on the comparable sales. making the appropriate adjustments for differences in square footage. We're having a range of 6 months prior to just after January 1st of 2022 of the comparables that we're estimating a market value for. Making an adjustment for the differences. The lowest value range is 2,912,000. Even if we were to take into consideration some cost to cure of that still needed, we're getting down to 2,712,000. That is still higher than the Prop 13 value for 2022. We believe that based on market evidence, the Prop 13 value that was enrolled for January 1st, 2022 is accurate and request that it be sustained as enrolled.
Alrighty.
Do you have anything?
Okay, at this time, I will take the testimony and the submitted evidence under submission, and I will deliberate after we have finished up all of our other hearings, and Brendan will notify you as to my decision.
Thank you.
All right, thank you.
I can go now?
Yes, and thank you for your patience.
You're welcome. Have a good day.
You guys like to come forward to
She's
the
not
table?
working.
Make yourself
I know,
scarce.
I'm reaching way over here to get my water.
So, right up.
So this is
There, there's its face.
Okay,
Maybe a little more, sorry. But it's-
Thank I'm exhausted. You guys should bring lunch.
They did bring lunch.
You guys did bring
They brought
lunch.
peanut butter and
Peanut butter and jelly. That sounds delicious. I know, I thought about it. It's like, oh, I should have told them to bring their lunch, but our hope is that everything goes quickly and we're done by lunch, but.
Well, I wanted to make our program last 7 hours, but she said, no, not to do that.
If it makes you feel any better, because I see you just filed this in April, it just so happened you got one of the last spots today. Normally it's about a year wait for a hearing,
Wow.
so you got a pretty quick hearing for just filing in April.
Okay.
So there's your bonus.
Right.
Um,
So of anything, let's go with that positive.
By the way,
What is this?
on the,
A copy of your application.
Oh.
So,
but you also did, with the other, you have this. Did you do a breakdown like I did?
Yes. So it will be
But I haven't received that yet, correct?
correct. You'll get it when we do our presentation.
Okay.
Okay.
and so to clarify, is this a Rule 2 challenge?
Yes.
Okay. So the applicant has the burden of.
Correct. So it is a base year appeal for change of ownership on April 25th, 2022. The purchase price was accepted, which was $730,000. As of that date of transfer and enrolled pursuant to Revenue and Taxation Code. Therefore, the burden switches to the applicant. And it is a tract townhome condo type in at 1710 Shoreline in Camarillo.
And owner occupied.
Correct.
No.
I do have a question on that. You signed under penalty of perjury. This is occupied as your primary residence, but the address, the mailing address is different than.
We did move into it, we changed.
Okay.
Did you check the wrong?
Which is not, it's not a big deal, because you're challenging the purchase price, it won't make a difference. In other circumstances it would, but I did just want to clarify that you do not live in the property, correct?
Okay.
And so you did not live in it as of the purchase date. We're looking backwards in April 2022, you did not live in it.
No.
Okay.
Okay.
Yeah, so it won't make a difference in this case. If, say, you were appealing next year, it would make a difference if you lived in it or
Oh,
not.
really?
But it won't for this.
Oh, okay.
Today.
Okay.
Just out of curiosity, how would they make a difference for next year? 'Cause
It presumes that if it's a January first value and you live in it, yes, you're presumed correct and the assessor has the burden to disprove you. Whereas today, when you don't live in the property, the assessor's presumed correct and you have to disprove the assessor.
Got it.
But today, because you're challenging the purchase price, that overrides everything and the purchase price is considered correct. But again, the 5% threshold rule will also apply to this case here.
Okay, so do we need to address the change in item 3 on the
It's not
application?
necessary to modify the application.
Okay.
It's
Okay.
fine. But we clarified it on the record. I did have that question, but it wouldn't make a difference in how we proceed today.
Okay,
It will for future years, but not today.
all right, so the applicant goes first. You know the procedure by now.
Yes, by the way, another question. You sent me over the comparable sales that you used. Should I just wait
Yeah,
until
we
you
can-
present it and then I can dispute it or whatever at that point?
So I think when I gave you the comparables that we were considering.
Yes.
That was like all of the comparables we were considering, and I think that's how you did your,
I do 2 sheets there.
yeah. So ours is just gonna be based on the 3. So you could ask us questions after we present our,
Very good. Okay,
presentation.
So it might be a waste of time to go through those.
Not necessarily. I mean, it will be your evidence, or you can ask us questions after we present it. Either way.
Okay, very good. Okay, we bought this house and when we bought it, we weren't sure if we were gonna live in it or move. Like everybody else, our living conditions changes based upon where our son lives and so forth. We decided that we weren't going to move, so we stayed in our original house. That's why the other address. About 2.5 years ago or so, I had a stroke, and I was an appraiser for 47 years prior to that. That's why I asked about Dan and so forth, because I actually met him at one of our meetings, because he's very much involved with the appraisal institute. So am I. So anyways, I had a stroke. We were in this rush to take care of things, and we simply paid too much. All the experience in the world just got past me, and I simply paid too much.
Well, we also were a little bit misled, so don't blame yourself.
Okay, well, you want to go ahead on this lady? She can talk also, right?
Yeah.
No, we were just, well, we discussed this. We felt like we were under a little bit of duress because there was one listing price and then we made an offer. And then they upped the listing price because they told us there were in their real estate office, there was a lot of interest, and that the unit down from us, which actually had a dock, ours doesn't have that, or deck on the water, was in escrow for $720. And without checking it out, we believed the realtor, and we were just, I guess you could say we were naive, or we trusting or something. And that's how we got to that point.
All right, and so anyways, in short, for our discrepancy in values, I came up with $655,000. I think that's very realistic. When you look at my comparable sales that I sent out, since I don't have yours, the main one I considered, number 1 at 1680 East Shoreline. That's also, we have a bit of a lake view, they have a lake view, but they're a lakefront home. So I took off $20,000 for that. They did not have the upgraded kitchen that we did, so I made a plus $20,000 adjustment for that. I also made adjustments on square footage over 50 square foot. I think you go by 100, so maybe that one is, no, that should be there because it's a different model, so it should make a difference. And then I gave a lot of value. We talked about this, the difference between us having a 3 full bath house as opposed to 2.5. And we believe our house was originally a 2.5 bath house. That somewhere or other they were able to decrease the size of the dining room and add in an extra an extra shower for that bath. So we're talking maybe 5 feet, whatever they did to increase that area. When I make the adjustments on those, which aren't all that significant, with similar detriments that we have, it adjusts to 655,000. And I think that's a pretty good price to start with. That had the least amount of adjustments. It had, of the 3 main comps that I use, it had the lowest gross adjustment of all of them. I know you guys use gross, and that also should consider, correct? Okay, we all know, okay. Next comp I used, also that one actually sold a little bit after our date, but it was so close in date that no time adjustment is really warranted. Next comparable sale, 1728 East Shoreline. This one has the same detriments that ours has as far as being near the traffic street and the noise and so forth, but it does not have the lake view that we have. So I gave a plus adjustment for the lake view. I gave a massive adjustment for the time, $30,000. And then no adjustment for square footage because they're almost identical. That one was superior in remodeling because it also had the baths were completely remodeled. Number 3 on mine, it's 520. Oh, by the way, all the comparable sales that I'm selecting here are from the exact same complex that we're in. So I think that's critical to use it. And that second comp adjusted to 659,000. Number 3 on 520, I think it's Taxco Court. That one also is very similar in square footage. Again, I made the adjustments for bedrooms and baths. I know you don't even do bedrooms, but not that much difference here. Again, it did not have the view, and it had a slightly smaller site size. These are attached, but they're still single-family homes. They're not condominium type ownership. I think they're called attached condos or something. Yeah, okay. And so that adjusted to 667,000. Then I go to my comp number 4, which I think is the highest price I found in the project to begin with. Is that correct? Yeah, it was the highest price that I found that I could use in the project. That sold for 662,000. Again, it is larger. It has the lakefront location. It has no detriments in that ours, like, it backs to a service road to a traffic street. So there's noise from the traffic street, even though we don't have to have any adverse effect from actual traffic going up and down, but we hear the traffic from the traffic street beyond. And let's see. And so that adjusts out to 611,000, which I think is very much down the road. And it sold, what, 3 months after our date, something like that.
This is not making us look good. I mean, smart, you and I.
I didn't say we were smart. I'm just trying to get the report right. But you're right. Comp number 5 on 1625 Dockside. This was a sale at 625,000. I don't think I can use this one because it's probably too far after the date.
Yeah, I was looking for clarification. You don't have specific dates of sales on here, is that correct?
Yes, I do.
It's only the month and year.
Because, yeah, so in yours, the restriction, you cannot use any sale after July 24th of 2022. I see, because you have months, is that correct?
Yeah, I can make adjustment by months, but.
Because, so like for comp 4, we don't know if it sold before or after July 24th, is that correct?
No, it probably, that would be the in escrow date, and the second date would be the closing date.
Okay, so it closed in August of 2022?
So you say that one's out of line?
You can't, yeah, you can't rely on that if it closed after July 24th.
You had several that I thought you were. Anyways. Well, then I guess we'll subtract number 5 then. And
And six
And
is,
6 is way out of line. Okay, and then can I use comp number 7? And 11?
Is that correct? It sold in 2011?
Yes, I guess I can.
2011.
you can go back as far as you want, but you have to make an adjustment to what you did.
Oh, okay, I mean, I can go back as far as I want. Okay, so that made a $45,000 time adjustment. This is a property on 1667 Edgewater Lane. That one had a very good lake view. It had a superior over, I don't know how to describe it, but from the location of the house, they just had a far better view than we had. And it was a lakefront. And again, I'm going pretty light on all my adjustments for homes that are on the water as opposed to our property, which has a view of the water, but is definitely not on the water. And so anyways, in light of all these details, again, giving most weight to, by far, to comp number 1. Again, larger home, so for $620,000. On these, I think I had the actual closing dates put down. And giving that one a plus adjustment for not having a remodeled kitchen. By the way, our house was, the kitchen was remodeled, the kitchen was nice. But the rest of the house was rather blah. It looked better in MLS because they had, well, like that vinyl floor covering that kind of looks like wood, but it wasn't.
Yeah, you never know what it's really like until you get in there and do the
Yeah.
cleaning.
So anyways, that's where most of my weight is, and I guess I have to look at whatever you're going to come up with. That's my argument. I think it's worth 655, or should have been worth 655 at that time.
Questions from the assessor to the.
Is there any other documents you wanted to discuss in your presentation
I
before?
think all these other things I put in there were the things that you requested.
Okay, but it
So-
wasn't something that you wanted to point out or anything?
Correct.
Okay,
Well, I have my comparable sales that you wrote down, or the comparable sales that you considered. I have those as each of your assessments, but I don't know if you use any of those comps. So did you use any of them?
Does it matter when you, after the fact, after you purchase it, if you find out things that you never even knew, like,
Well, were you here with the one fellow, we were talking about the transfer disclosure statement, or seller's property questionnaire?
I don't think so.
Oh, okay. In real estate, before you buy a house or make an offer, the seller should give you what's called a
A
transfer
disclosure.
disclosure
Yeah,
statement.
yeah.
And that questionnaire. And that forewarns you that, this is older,
The wind
Raising
blows
the-
all the garbage to the end
Raising
where
the
your
flag.
unit
It
is.
doesn't show
So
that.
typically the sellers do that, so you can make an educated decision to buy the house. And so, like I told the other applicant, that's probably more important than the purchase contract
Yeah.
in some cases, because that's a legal document. So I would say read through that.
Okay.
As far as things that pop up later. That would be my advice. Okay, questions from the assessor to the applicant?
okay, so none of this really is not new to me. I've seen this stuff before.
All of that was sent to you.
Yeah,
So my question would have been, well, you kind of already answered it in the sense that you said that your realtor had that, that there were others that were interested and that's why you were willing to pay that amount.
Well, we actually even asked her, what do we need to do to get the property, which was stupid, and I should have never done that. We should have just decided.
Okay. Was there a bank appraisal done on this?
No.
There wasn't. Okay,
No.
so you didn't have anything. So you were aware at the time when you purchased it that it was going to be sold to you at a price that was higher than what the comps.
No, not the,
No, not at the moment.
not the comps. We didn't know.
Yeah, you just knew you were paying more than what you were willing to pay more.
No, we thought we had to buy it now or we lose it. And again, I think it was a
Well, I
kind of
think,
a stress situation that was put upon us by the broker. Again, I should have been knowledgeable enough to realize that it was too high, but the broker said it was just fine. So I guess we were trusting the wrong people.
Okay. And then my next question might have to do with, because of, you'll see our comps in a few minutes. But I think just having to do with the fact of this lake community. Typically, I would think that buyers who purchased with the lake view were buying it for that reason. Yours not having a lake view property.
That's probably true. I don't know what their actual motive was, but the
Yeah.
sales prices clearly are higher on the, let's call them the lakefront homes as opposed to the non-lakefront.
Right. Okay. That's it.
Okay, and I do see you've included with your package here, you did a physical inspection with a
Yes.
licensed contractor and got all of that information guidance.
We're not disputing that.
that was primarily for the roof because we'd seen rusting water on the roof, so we wanted it checked out. And that's what that primarily was, but we got it checked out and we took care of it.
Okay, now we'll hear the assessor.
I wish I could have seen you earlier.
It shouldn't be a surprise. I think we discussed most of the comparables anyway. So if you wanted to look at the market evaluation, that's on page 8. So that's just the photos of your listing. And page 8 is going to get you our breakdown of what adjustments were made. So
What are you doing now?
yes, just the one, just for size wise. So again, this is a base year appeal for an April 25th, 2022 date of transfer. We received a purchase price of $730,000 as of that date of transfer. Per our market evaluation, determined it to be fair market. The subject property was listed on the open market. It was listed and transferred at arm's length between unrelated parties, both represented by a broker. Per the Property Tax Rule 2 provides a presumption may be rebutted by evidence that the full cash value of the property is significantly more or less than the total cash equivalent of consideration paid for the property, with a deviation allowable of no more than 5% of the total consideration. So the assessor's appraisal indicates that the purchase price falls within the adjusted value range of the comparables used and therefore considered fair market value. The appraisal includes 3 comparables, all of which are comparable in size to the subject and are less than 0.1 miles away from the subject in the same market area participants would consider when purchasing a home. The subject has updates and is considered to be in an updated average condition. All comparables were adjusted for the inferior bath count to the subject. Comp number 2 is slightly inferior in condition as it lacks the updates to the kitchen compared to the subject. Comparable 2 also has an inferior lot size as it lacks a driveway with their garage and is adjusted upwards to account for that inferior improvement. They just have I believe, an encroachment to their garage. They don't have a garage and a driveway. So that's the difference in lot size.
Oh, that's the one that comes in on that other screen. Okay.
So comp 3 is adjusted downwards for having a slightly larger lot size due to the added area and for superior water access. Comps number 1 and number 3 are also adjusted for having inferior garage sizes. The other adjustments include for an inferior or superior exterior miscellaneous improvements. That would include for, covered patios, porches, if there's barbecue areas, things like that. The sales dates of the comparables encompass the sales date of the subject to include directly before and directly after the subject's April 25th, 2022 transfer date. The assessor's appraisal indicates that the subject's purchase price of $730 was fair market under Property Tax Rule 2 as of the purchase date of April 25th, 2022, and therefore requests that the appeal court sustain the enrolled base year values as of that change of ownership. On page 3, you can see the listing description, and pages 4 through 7 are just some of the interior photos of the subject property that you can see, the updated kitchen and the bathroom and other areas. Again, our market evaluation on 8, which shows the adjusted value range and the subject's purchase price of $730 within that range. And then pages 9 through 22 are the comparables used with their listing photos and listing descriptions to show the differences, from the subject property and the condition of those comparables. I wanted to make sure, yes, on page 17, you can see the back of the one property that doesn't have the driveway. It just has the encroachment to the garage through like an alley. And then on page 23 is just the map of the comparables to the subject. You can see where they are located within the community or within the same market area of the subject. Do you have anything to add?
No.
Okay, so that concludes our presentation. Okay, questions?
Yeah, why in the world would you use the, and you use it as comp number 1, right? Let me get to that. It's,
2 Del Prado.
it's comp-
508 Del Prado Drive.
Yeah, I mean, you have it as comp number 1.
Mhm.
That's in a different project. Did you consider the fact that the homeowners association fees in that project was $185 a month? Whereas the homeowners fees in our project were $450 a month, which recently went up to $500 a month?
I don't know if we have
That's
that
good.
information.
That was on the MLS.
Yeah. Also, this other comp, I recall that one,
That was sharp.
that was really, really like totally redone. with
Yes.
Molding and beautiful tile and
Which one are you
granite.
talking about?
Comp number 1 on your report.
Comp number 1.
Yeah, so the 508 Del
That's the
Prado.
one that's in a different complex. across from us.
Right, so it's comparable in square footage, sold and was listed on or around the same time as the subject. Comparable lot
Yeah.
sizes.
You have my adjustment grid. I think they call it comp number 12 in the information I gave you.
I think their question was regarding upgrades.
Well, upgrades are included in my adjustment. Yeah, okay, adjustments to condition, pretty low. That one was completely remodeled and you didn't take off. I mean, you have similar updates. No, that house was so nicely upgraded. It was ridiculous. And you didn't make an adjustment for upgrading or condition.
Based on the listing photos, we felt that the condition was comparable. We both had updated kitchens.
We
We
were
did-
actually in that unit.
That unit had, we had like laminate floors. They had tile floors throughout. These are also one-story homes, which is a slightly different market. You didn't even mention that. I didn't adjust for it, but it's something to consider. Those homes are in this project that have these wide open space areas. So they're one-story wide open space, you have big families and will play in the open space. We don't have any of that. We have like this really tiny little backyard area. And it's a different project. It seems like if you're going to be in a different project, you're going to select comparable sales from a different project. You should adjust for that when noted. And that's why those properties sell for more. And I think I brought that out in the comparable sales that I use. They do sell for more.
So just to answer that question is that typically we would prefer and we do encourage to use within the same, what we call same district neighborhood, but it's the same community. However, in this case, with your property being, some properties have a view of the lake. And in that case, if your property had a view of the lake, we definitely would have only used comps that had views. It would not have made sense for us to have gone outside of that. But because
this comp doesn't have a view.
Yeah, oh no, I'm saying if you had a view on your property and you were on the lake, it would have been very important for us to have valued it using comps that were on the lake with views.
Well, we do have a view of the lake. We're just we don't have the deck that is actually on the lake.
Yeah, so we don't have record of.
Which the one that is on the lake, we made an adjustment
For
it being
for the
with
dock,
water
for
access.
The subject lacking it and for the comp having, right?
Yeah,
For
so
having the
comp
view.
number 3, the adjustment for the water access downwards.
Right, so,
And the decking is adjusted for.
Yeah, it's
the
a lot
plus.
larger.
right,
a lot
so,
larger.
so using a comp that was, and the fact that you were in comp one kind of, it confirms what we were believing, that it would attract the same type of buyer. And that was the reason why we were using it as a comp. And like I said, you being in there, looking into that property confirms that. However, knowing that it's right across the street, all other things, if you can see, there are very minimal adjustments. There's 5,000 for the difference in bath, 3,000 for the difference in garage size, and then 2,600 for the difference of
Yeah,
the.
it doesn't have any covered
Yeah,
area.
it's either a balcony or a patio, but all things lot
Oh.
size, everything else is.
Oh, no,
the
Del
same.
Prado they actually had a beautiful front patio and a back patio.
Not covered, not a covered area.
Well, ours doesn't either.
Yeah, ours isn't either.
There's a,
Oh, there's a cloth thing that has to be
Yeah,
replaced.
yeah,
It's got scratches
it's
in it.
bad. There's like a cloth, I don't know, on stilts, what would you call it?
Yeah, there was
poles with a covering, but
it's an
that,
attached covered
that is-
patio.
That'll be replaced probably in a couple of years. Because it'll
Maybe.
fall down.
Yeah,
Right.
it's,
It's
there's
not a covered patio.
that, I don't think that should be given any value.
And then you have 3 comparable sales. Comp 2 and comp 3, again, in the same project. I've got no problems with that. I don't even have problems with the adjustments you made for it. It's just that why is so much weight given to comp number 1? As an appraiser, we always put most weight on the comparables that have the that are most similar to the subject property. And this one is in an entirely, I know it's the same market.
Right,
I'm
but this
not
one would
arguing-
be the most similar in the sense that it does have the least amount of adjustments compared to.
No, it
comps.
doesn't have any adjustments. It
2
doesn't
and
have
3.
any adjustments for,
It's being adjusted 10,600.
In comp
it
2.
doesn't have any adjustments for being in a superior project. It's one thing to say, yeah, the market would consider it. Yeah, of course, the market would consider going to a superior project. That doesn't mean you're going to pay the difference.
Yeah.
This is a superior project. The sales prices are higher throughout the board. If you do a paired analysis adjustments for each of the comps in this property and each of the comps in our property, you will see that these sell for more. That requires a negative adjustment. And starting with just the adjustment for the homeowners association fees. You've got to consider that. Boy, I've been doing appraisals for a long time, and I have to consider that. That's on one of the adjustment grids of a Fannie Mae appraisal.
We would have preferred to live in that complex too.
Yeah, we would have preferred that complex. But we couldn't afford it, or we didn't want to spend that much money. Oh, I still have to have. I'm sorry.
We don't need
Do you have any more questions? Or?
No, I mean, because I see your point too, but I also was, you know, we know what happened with our transaction, so.
And this, you know, it's one thing to say that, oh, hey, this is a great comp because there's no adjustments. That's meaningless to me because there should be a bunch of adjustments, and I made all the adjustments there. The way I think they should have been on comp 13 and on mine, which is the same as your one.
Yeah, but if you're referencing a location adjustment, is that what you're referring to?
I'm putting everything in the HOA dues. You have a difference of HOA dues of about $285, whatever it is. Imagine buying a property where every month you got to spend $285 more every month. Isn't that worth something?
I mean, I definitely agree that that would be something to consider, but yeah. However, that's not exactly something that we would adjust for on here. I mean, I think it's something to acknowledge and to consider.
Well, they didn't have the knowledge.
Yeah, I'm not sure. We've
never
this
done
for
it.
many years
Right.
and
Although
HOA,
I do
think that's
recall,
something that's going to come up in the future.
Yeah.
yes,
Yeah, for sure.
yes,
Yeah.
because I recall when you were doing appraisals.
Yeah,
He always called to find out what the HOA fees were.
Right.
And everything.
That would be
Well,
like
I
a
mean,
Mello-Roos payment. If some properties have Mello-Roos that are different amounts, you have to make an adjustment for the different amounts of individual payments that'll be, you know, in effect for like 30 years or whatever. In this case, it's indefinitely because it's a different HOA. And
Right,
so,
and I just can't help but to think that HOA, what's included in there is to maintain and to upkeep the actual lake that's in there. However, it's not that we're not acknowledging that there's a lake there. It's the fact that because we're not adjusting for any views on your property, like directly from your main living area.
Yeah,
That can you even see the lake from where?
from the kitchen window.
But from your main living area.
yeah, from the living room, you can see the
Yeah.
corner of it.
I think so, yeah.
By the way, all those factors I put into my adjustments. And so,
It's based on the photos. Yeah, I mean, based on the photo for the main living area, you see the property across the way. So for that, I mean, for that reason, we don't have your property as a view of the lake.
Oh,
I mean, it's acknowledged that it's in the community, but I think that's just one of the points that I'm just trying to point out is that.
yeah, I get it.
Yeah, comp
Okay.
number one.
If you want a picture, I can send that to you. Oh.
So we're not denying the fact that it's in a community with the lake. It's just the fact that we don't have on our records that there's a view, nor do the pictures support that there's a view directly like from the main living.
I'm not
area, which is how
arguing, I'm not arguing
Yeah.
the viewpoint at all. The
Might
one
be
thing
the
I'm-
HOA.
if you took an analysis,
Right.
paired data analysis between one and the other, you'll find a significant difference. Certainly, more than what you have here. You have, matter of fact, your adjustment grid 652, 665, and 730. I was reviewing an appraisal and I saw something like that. Whoa, what gives on here? Why not select
Which one's that?
the adjustment that you just gave me, market analysis that you just gave me? You have comps 1, 2, and 3, and you have a massive adjusted value amount. I mean, that's significant.
So I mean, you can look at it two ways. The way that I'm looking at it is that here we chose comps that were close in time to the subject property, that were close in proximity, all 0.1 miles. And the one property that is, well, yeah, the one property that is in your community.
Two.
Actually, there's two, but the one that's in your community that has views, to me is actually less comparable than what comp one is, because the fact that when you look at all the adjustments here for the views for your property that doesn't have views, and we used comp one that did not have views that's spread across the street.
So,
Well, but
I
kind
mean, I'm
of.
not saying that the community that would be the preferred, yes, I do agree. And had we had 3 comps within this time period that was in your community without views the way that yours are, then those would have been ideal. But we don't have that. We have 2 that are in your community, one of them with views and one of them without.
Didn't have the.
every one of the comparable sales that I chose, for example, all 7, I know a couple of them are out of line because of dates. But again, if you're an appraiser and you find the best comparable sale with the lowest number of actually both net and gross adjustments, the 1680 shoreline is by far the best, and you're using it, but you're not putting any weight on it. It seems like you're putting all this weight on the $730,600 adjustment, which doesn't make sense. In short, if you choose a comparable sale in a different project and you're putting more weight on that than the comparable sales that are within the project, I think you're making, I don't want to call it an error, but you have to make an adjustments for each of the variables, and you're not making any adjustments for that variable. That's my main argument with everything here. Everything else is an agreement.
So as an appraiser, if you had beachfront, or if you had properties that were all on a beach, they were all comps, your subject was beachfront property, and you definitely would want beachfront comps, not just properties that are on the beach, right?
Correct.
So in a sense, you could kind of look at this, that yours is not beachfront property, it's on the beach, and there's other properties.
I'll take that back. There are times when I've made adjustments, certainly in Malibu, if you want to get into technical things. The properties don't quite have beachfront property, but they're close enough. There was one property sold for $80 million. It was across the street from the beach, but it had a spectacular view, and I had to use beachfront properties. You use the best comparables that you can get.
Right.
To not use comparables just because they don't have a lakefront is kind of ridiculous, especially since the lakefront view that we're having actually adds to our value. So, I mean, the adjusted value.
I think where the assessor stands is not necessarily we're putting the most weight on comparable 1. I know it's comp 1, but it doesn't necessarily mean we're giving the most weight. I think because of the fact that this was a Rule 2 open market transfer, where it had the opportunity to be exposed, it had the opportunity for multiple bids to be coming in, and we were given a purchase price of $730 as what was indicated to be what a purchaser believed the value of the property was as of that date of transfer, that purchase price falls within the range of adjusted comparables, where we still had the availability to go 5% over that adjusted value range.
One way over.
So even if it's not so much that we're giving most weight to this comp, it's that because it's a Rule 2, we were given a purchase price based on other market participants and what would occur at that time. The purchase price is supported based on the Rule 2 sales because it falls within the adjusted value range. This value is a range. It ranges from 652, 600 to 730, 600. So it's not that we're saying per se comp 1 is the most comparable, but that because under the Rule 2 guidelines, it is supported based on other comparables.
Okay, and then my argument against that is, fine, use it if you think it's necessary, but it just for the fact that it's in a better neighborhood. If you're going to be, really do a good appraisal on it, you would do some type of analysis between comparable sales in one project and comparable sales in another project. You get a paired data analysis between the two, so you can make that adjustment. We didn't have to do that with comps 2 and 3 because they're in the same project. When you do that, when you consider all the adjustments that I considered, it's far less. And we looked at this property and that was a far better home. I guarantee it.
Yeah.
Again, tile roofs, I mean, not tile floors, the open expanse.
Big kitchen. Our
We-
kitchen is tiny.
Yeah, this is a larger kitchen. Look at just the granite in the kitchen. It's much more substantial than
It
ours.
had molding and upgrades and bookcases, and it was a really nice.
We're basing everything on this one comp in a different project of a far superior home, and I don't think that's the best way.
You know, Audrey, I think the reason we're a little bit surprised is because we talked a lot with you, and
Right.
you did kind of indicate.
I can agree that your purchase price is the highest in
Yeah.
Yeah.
this tract.
Yeah.
I can 100% agree to that. But the fact that it is a Rule 2 sale, where you had the opportunity to put in an offer, there was competition, all those guidelines. I guess, I don't want to say you're forced to accept it as
I think
as
you,
fair
I
market
think you
value,
put
but
it correctly.
it-
They have certain guidelines that they have to follow.
Yeah, and we
When-
talked about those guidelines, and you said, I do recall you saying that you felt that it was outside the 5%. And that we had a good case, and
I did say that I do believe your particular purchase price was high. But again, when we have to replicate the market and what an active participant in a market would look at it, and it wouldn't necessarily be just in one community, it would be maybe in a specific market area. When we have to replicate that, and not just look, like I said, just the comparables in the track, then the purchase price based on the guidelines is accepted or is reflected of the market conditions at that time. Is yours the highest in that tract? Yes, possibly.
yeah, especially since one just sold for $600,000 in April. I mean,
But-
this is crazy.
And I just wanted to let you know, for the ones that you did provide that were outside of that 90
The
days.
date, yeah.
Is something we definitely can consider for not for a base year, since they're outside the 90 days for base year, but is something we definitely consider for a Prop 8 value as of January 1st of 2023. But again, yes, is your purchase price for your particular community high? Yes, but there's with a range.
Well, I have a question. Is it outside that 5%?
Yeah, you're not coming up with a specific
No,
value.
no.
You're coming out with just a range, and then you're picking the highest one from the range.
No.
The 5% is like 693,500.
The range is 650 to 6.
No, I'm talking about
730.
the 5% lower than.
So it would be 5% above 730,
meaning the lowest-
600. So you can be 600, or you can be 5% above the highest or 5% below the lowest.
So if I take 0.95,
It's 695,238.
that's what I came up with, yeah.
Yeah, and then do you have that 690?
Wait, how did we come up with that number?
But that's just the 5%
95.
threshold in order to adjust
Oh.
the base value.
Oh, I see.
So yeah, the
Okay,
threshold is 695 and some change.
okay.
Look,
Yeah, so I'm not gonna deny it. So I'm not gonna deny the fact that it appears that your sales price is higher than others within your neighborhood. However, the market's created by what buyers are willing to pay. And the fact that the property sold and there's market evidence to support that sales price as being fair market value. That's why we're here today with the case, because we have comps that support that 730.
You have.
We're not saying you didn't
You
pay.
have one comp.
We have three comps here that
Well,
have a range of.
You could have gone to the
650
hillside properties and selected something that cost $1 million and adjusted it. In short, with appraisals, you always find the best comparable sales. And this one is not a comparable sale. It's in a different project. I'm not arguing anything else you're saying. I'm just saying this is in a superior project. You've got to make an adjustment for that. By not making an adjustment for that, that's why you're coming up with the 730,000 for this one comparable sale. And then secondly, again, I know you have your procedures and rules and so forth. Boy, if I did one appraisal and I put everything on one extremely high appraisal, really high sale, as compared to the first two, which are so close in adjusted values, I think something is really wrong with the appraisal.
Okay, I think I'm going to do a point of order here. Are we completed with questions?
Oh, yes, I'm
Their
sorry.
Presentation?
Yes.
Okay, so we'll do, yours was more of a closing statement, so we'll do closing by the assessor and then closing.
I'm sorry. You're absolutely
That's
right.
okay.
So again, we're disputing a Rule 2 open market transfer for a April 25th, 2022 sale. This was a listed property where there were active participants able to put in offers. The purchase price was over the original asking, but for our appraisal, it does fall within the allowable range or within the 5% deviation under a property tax Rule 2 guideline. There was, it was an arm's length transaction with unrelated parties that were both represented by brokers. Therefore, it justifies and supports the Rule 2 guidelines the assessor is bound by, and we request that you sustain the base year enrollment as of the April 25th, 2022 date of transfer.
Okay, and before you do your closing, just so I have the numbers straight here. As you mentioned something different than what's on the application. The assessor is recommending 730,000, correct?
Right, the purchase price 730,000.
And the applicant's opinion of value?
I think on the the application shows 650, but I think in your presentation, I think it's 655.
Sorry.
That's okay.
So,
That was a mistake.
yeah, but that's okay. So what is your opinion of value?
655. Well, on the high side.
Okay. All right. I just always like to have that.
Mhm.
Really. Okay, closing.
Again, I understand the rules, but it doesn't seem fair that the rules are designed to select one comparable sale that's going to take it out of the category of making it a valid appraisal. Because I think we've got valid appraisals going here. And when you start to analyze the results of each appraisal, you're not coming up with anything even close to the sales price. The 730,000 adjustment that you made for one comparable sale seems to be way, way out of line. If you had chosen something from in any of the market ranges that you had for the comps 2 and 3 in that, you would have come up with something in the basically what I came up with the 655,000. So basically, I think we're almost in opinion, the same opinion of value, but you're selecting, or the state is selecting, or the county is selecting one sale that I think is way overpriced, or not overpriced, but it was just a far superior home, far superior area. When you make those adjustments to that comparable sale, it supports my case. And personally, I would never have even used it because it's in a superior neighborhood. There were other comparable sales you could have used. End of statement.
He's really a nice guy.
Oh, I know he's nice. We were able to talk to him.
Oh, yeah.
Okay, I will take the testimony and the evidence under submission. I will deliberate, and Brendan will notify you as to my decision. But also a reminder about the Prop 8 for the following year.
Yeah, Audrey already explained it to me, so I understand this.
Okay.
Hopefully we won't have to do that.
Are you sure you didn't want to go back to appraisal?
No.
Hopefully the assessor's office.
Oh, yeah, there's
something there is, I received something in the mail from, I don't know if my license is still good. Whenever there's, an opening, you send it out to license the Braden, so I think I got something.
Oh, really?
Yeah.
I did.
There's also an opening on the assessment appeals board.
There is. Yeah.
Oh,
Yeah.
I don't think it was that good, so.
Thank you so much for your time.
Thank you for your.
Yeah.
it was great meeting you both. Thank you.